Court officer? Court officer? Court officer? So ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ ಮೇಡಮ್.
ಕೇಳಿಸಿದೆ ಅಲ್ಲ ಮ್ಯಾಮ್? ಓಕೆ ಮ್ಯಾಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಅದೇ ಮಾಡಿಫಿಕೇಶನ್ ಏನೋ ಹಾಕೊಂಡಿದ್ದೀರಿ ಅಂದ್ರಲ್ಲ, ಒಂದು ನಿಮಿಷ ಇದೆ. GMC ಅಲ್ವಾ? ಒಂದಿನ ಬರೀ ಡೇಟ್ ಗಿವನ್ ಮಾತ್ರ ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಏನಾದ್ರು ನಾಳೆ ಒಂದ್ ನಿಮಿಷ ಕೇಳ್ತೀನಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್.
ಡಿಗ್ರಿಯಿಂದ ಲೇಟ್ ಆಗಿ ಬಂದಿತ್ತು ಅಂದ್ರು, ನೆನ್ನೆ ಇವತ್ತು ಹಾಕಿ ಅಂದ್ರೆ ಇವತ್ತು ಹಾಕಿಲ್ಲ.
ಹೌದು.
ನಾವಿರ್ಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಆಫರ್ ಕೊಡ್ತೀನಿ.
ಫೋನ್ ತೆಗಿತಾ ಇಲ್ವಲ್ಲ ಯಾರು? ಇನ್ನೊಂದು ಏ ನಂಬರ್ ಇದೆಯಲ್ಲ ಅದೆಷ್ಟಪ್ಪ? ನೀವು ನದಿ ನೀರಲ್ಲಿ ಸಿಕ್ಕಿಸಿದ್ರೆ
ಇಲ್ಲ ಅಂತ
ಕರೆಕ್ಟ್ ಆಗಿದೆ. 11 ಇರ್ಬೇಕು. ನಾನು ನಂಬರ್ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಿದ್ದೀನಿ. 10 ಅಂತ ಸೇರಿಸ್ತೀನಿ.
ಇನ್ನೊಂದು ನಂಬರ್ ಯಾವ್ದಪ್ಪ ಅದು? ಅಯ್ಯೋ ಇದು FC-ದು 134. ಅದೇನು ಅವ್ರಿಗೆ 813 ಫೋನ್ ಇಟ್ಟಿದ್ರು, ಫೋನ್ ಸರಿ ಇರಬಾರ್ದು ಅಲ್ಲ, ರಿಂಗ್ ಆಗ್ತಿದೆ. ಮಾತಾಡ್ತಿದ್ರು ರಿಂಗ್ ಆಗ್ತಿರುತ್ತಾ? 134
ಹಿಂಗಾಗುತ್ತಾ ಅಷ್ಟೇನ್ ಕೇಳ್ತಿದೀನಿ
ಟೆಲಿಫೋನ್
ಮೇಡಮ್ ಸಿಎಗಳ ಮುಂದಿನ ವಾರ ಕೊಡ್ಲಾ
ಏನು
ಸಿಎ ಮೆಮೊಗಳು
ನೋಡಂಡಿ ಇವಾಗ ಏನ್ ಹೇಳ್ತಾರೆ ಕುತ್ಕೊಂಡಿರೋ ಸಿಎ ಇಲ್ಲ ಹಲೋ ಸರ್ ಇದು ಅದು ಯಾರು ಮಾತಾಡ್ತಿರೋದು ಸರ್
ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇನ್ನೊಂದು ಬೇಕಿತ್ತು ನಮಗೆ ಬೇರೆ ಎಲ್ಲ ವಿದ್ಯಾ ನೋಡಿ
ಎರಡು ಬ್ಯಾಟ್ರಿ ಆಮೇಲೆ ಇನ್ನೊಂದು ಕೆಳಗಡೆ ಇದೆ ಇನ್ನೊಂದು ಕೆಳಗಡೆ 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 ಮೇಡಮ್
ಇದೆ
ಆ ಡಿಗ್ರಿ ಬ್ರಾಂಚ್ ಇಂದ ಬರೋದ್ರ ಲೇಟ್ ಆಯ್ತು
ಬಂದ್ಬಿಟ್ಟು ಆ ಕೇಸ್ ಬರಕ್ ಹೇಳಿ ಒಂದ್ ನಿಮಿಷ ಬಿಡಿ ಸರ್ ನೋಡೋಣ ನಾನು ಅದ್ ನಂಬರ್ ಬರ್ಕೊಳ್ಳೋ ಬಿಂದು ಇದೆಯಾ ನಮ್ಮ ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ವಾ
ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್ ಇದು ಕೊಟ್ಟಿರಲ್ಲ ಮೆಮೊ
ಇನ್ನೂ ಒಂದ್ ಮೆಮೊ ಕೊಟ್ಟಿರಿ ತಗೋ ಇಟ್ಕೊಂಡಿರಿ ಸರಿ ನಮಸ್ತೆ ಮತ್ತೆ ಯಾವ್ದಾದ್ರು ರಿಪೀಟ್ ಆಗುತ್ತೆ ಕಂಪನಿ ಮ್ಯಾಟರ್ಸ್ ಒಂದು ಕಾರ್ ಲಿಸ್ಟ್ ಈ ಕಡೆ ಕೊಟ್ಟಿರು ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಾ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಆಗಿಲ್ಲ ಅಂತ ಕಿತ್ ಕೊಡ್ತಿದ್ರು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಏನಕ್ಕೆ ಎಲ್ಲ ಫುಲ್ ಎಂಟೈರ್ ಲಿಸ್ಟೇ ಎತ್ಕೊಂಡು ಹೊಟ್ಟೋಗ್ತಾರೆ
ಸಪರೇಟ್ ಮಾಡ್ಬೇಕು
ಅಲ್ಲ
ಇದೇನೋ ಇದು ಬೇರೆ ಮೆಮೊನ
ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರೇನು ಕೇಸ್ ವರ್ಕ್ ಅಂತ ಬರಕ್ ಹೇಳಿದೀನಿ ನೋಡೋಣ ಇದೆಯಾ ಆಮೇಲೆ
Yes, file.
ಒಳ್ಳೇದು ನಮ್ಗೆ ಯಾವುದು ರಿಷಿನ್ ಹೌದು ಮೇಡಮ್ ನಾವು
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ ನಮ್ಮಲ್ಲ ಪಕ್ಕ ಟೋಟಲ್ 20 ಇದು
21 ಗೋಜು.
ನೀವು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ನೋಡಬಾರ್ದು. ಸೀರಿಯಲ್ ನಂಬರ್ ವೇರಿಯೇಷನ್ ಇದೆ, ಟೋಟಲ್ ಸೆಪರೇಟ್ ಲಿಸ್ಟ್ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 1920 ಅದು ಮೈನ್ ಇದೆ ಅಲ್ಲಿ ಟೋಟಲ್. ಸಿಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊತಾ ಇದೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಗೊತ್ತಿಲ್ಲ ಸರ್, ಮೇಡಮ್ ಬಂದ್ಮೇಲೆನೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಪಬ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
List number 2. Page 1, serial number 1.
Last case, day before yesterday, their matter has been asked. Cleverly, previous council has filed no objection, retirement now. For the last, it's almost 5 years. Today itself, we can fight. Today.
That's what tomorrow we'll have. Anyhow, there is a, what is the likelihood of this, this speaking and all this, remit writing, we'll have it tomorrow. Doesn't matter one day.
Monday.
No, your counsel then has given you no objection in wakalat, if you give all the material, it won't start from the day you find wakalat. Yes.
Serial number 4, Millard, serial number 4.
Serial number 1 tomorrow.
One tomorrow. So,
Post first week of next month, Your Lordship.
Serial number 4.
Because of I am not well. There's some throat infection. Very petitioner only.
third of February.
Published.
Kindly, my lord. In number 3, my lord, 2 days accommodation, my lord. The file has been misplaced in the office, my lord, for the renovation work. The file has been misplaced, my lord. 2 days accommodation, I'll go on. I'm sorry, my lord. I was on the waiting for that time, my lord. I apologize for that, my lord. I was on another court order. A week's accommodation, my lord. Because of the renovation work, some misplaced.
No further attendance, both the matters on the same caption. This was the.
My lord, on 4th, my lord.
Third.
Obliged.
Yeah.
Serial number
52, kindly. Adjournment.
That is list number 2, sir. List number 2.
Yes.
My lord, with the permission of the court, list 1, the serial number 43,
Have to wait till the matter.
please.
List number 2.
Follow.
List 1. For orders matter, serial number 1.
Please, Lord, appear for the official liquidator and the matter, Your Lordship.
Appear for respondent number 3.
Lord, this CA 789 of 2004 is filed by the official liquidator under section 454 of the Company Act for non-filing of the statement of affairs. A winding up order has been passed on 16/6/2004, Your Lordship. Even till today, they did not file the statement of affairs, my lord. Some of they have been absconded. Now they come up with the 2 CAs for different, for staying of these proceedings, my lord. I'm seriously opposing for this because for a long time they are absconding and they did not even file the statement of affairs. Only when the section 82 of CRPC application is filed, then they come up with these 2 applications. I'm seriously opposing for this. If at all they wanted to file the statement of affairs, Lord, the documents which are available under the ROC online, they could have to file it within a week. So not more than that. I'm seriously opposing for those 2 applications.
Raj, if I may submit, I am for respondent number 3. In fact, I have cross-examined the witness, the OL witness, and actually I am ready for hearing. I think the applications 201 and 202 have been filed by respondents, accused number 1 and 2, respondents number 1 and 2. So,
There is a counsel for respondent.
D. Prabhakar Saratri.
much.
Serial number 2.
Lordships, in this case, I appear for the applicant. I have filed an application to recall the order placing the cross-examination PW1 as nil, my lords. 4 or 5 times witness was absent. And another day, when I went to chamber, they said the other connected matter is going on. By the time I went back again, they have taken as nil. That's the only issue, my lords. I have to, my lords, order is dated. And it turned to my affidavit at paragraph number 3. As paragraph number 3, my lords.
Para 3 of the affidavit.
affidavit minutes. As the connected 181 and CA number 328 so and so 23/4 the application was adjourned to 24/4 next day itself minutes. And 13/3/21 and 24/24 the counsel for the respondent in CA so and so was held up in a matter in the court hall, and by the time he reached the chambers for attending the quest, it was called out and marked absent. It's not, that's the only thing matters. 23rd again 24 that connected matters. Previous 3/4 dates matters. Kindly see paragraph number 2.
You absent. The date was
13/3/21 and 24/4/24 minutes. 3/21 and 24/4/24. Witness was absent on all other 5 occasions, previous page minutes, paragraph.
this
Now, application was filed on 26/11/24 minutes. Matters, it was posted for respondent's evidence. So that was contacting officers because 1997 transaction, the ministry has been changed and merged with some other department. Yes. Yes. Yes, madam. Yes, yes.
and then once you
Madam, to get the instruction, the officers from Delhi, madam's office was closed and merged. Yes, madam, it was posted for respondent's evidence, madam. I communicated, I had several rounds of this thing. I understand that's one opportunity for this. It's not any date fixed, madam. I will make it because kindly see the previous day, 4 or 5 occasions he was absent. Suddenly they said he had come for other matter and I inquired with them. I attended all the matters. That's the only thing. One day any date fixed, madam, or closed on that day itself. Other than that, it's amount claiming. Yes, yes, yes.
My lord, it's a government institution, my lord. The date may be fixed, my lord. On that day, my lord, let him not
I will not.
take time.
I will not.
Otherwise, my lord, any date, my lord, because it has to go before CPC for evidence, my lord. There, any date convenient to him.
Any
so I
date
will-
minutes. I
will
will
keep
subject to
my
witness
witness
this thing.
prepared.
Witness. Yes, sir.
4th of February.
4th of February, fine minutes. 4th of February.
It is okay. Yes, madam.
4th February.
Yes, madam.
411, there's a delay in filing the
My lord,
application.
he has made 3 applications, my lord. One is permission to reopen.
Rework.
Another is
411, only 2. This only 2. Earlier it was taken.
my lord, CA 410/2024 is to reopen the case. Then
410.
411/24 is recalling that order
That-
dated so and so.
That's 410 minutes. Yes, only 2 applications.
Only 2 applications, sir.
Only 2 applications.
410 is for reopen.
Common order in CA 410 of 24, and then CA number 411 of 24. Number 410 of 24 is 5. In filing the application, but recalling the order dated 24/4/2024. Taking out the transaction of period 1 as well, in CA number 607 of 2008. And the CA number 411 of 2024 is 5.
To recall the order dated 24/4/20.
Recall the order dated. So, taking the course examination. As well. It is stated by it is stated that the council applying to the respondent is CA number 607 of 2008. At the final memorandum of reference on 7/6/2018. And the CA was posted to 23/11/2021 for cross-examination of PW1. And PW1 was absent on 13/3/2021. And he was present on 23/5/2022. And was absent on 2/8/2023. L1/2024. 12/2/2024. How many days you were absent?
No, not me. PW1. One was absent.
Everyone was absent. We stated that on 23/4/2024 and 24/4/2024. And the further CA number 607 of 2008 and connected CA number 187 of 2009. The CA number 302 of 2008. And on 23/4/2024, the application was adjourned to 24/4/2024. On 13/2/2021 and on 24/4/2024, the counsel for the respondent was held up in a matter in the court hall. And by the time they reached the chambers for attending the case, it was called off and marked absent. It is stated that the absence on the said dates was stated that it was for a bona fide reason, and it was not intentional. The council appearing for the points of its the intentionally, the petitioner is not selling, has not cross-examined, and rightly an order was passed to the court, treating the cross-examination as nil. Next one. The council appearing for the petition before this one, council appearing for the petitions of its is ready to for cross-examine PW1, and any date may be fixed. Considering the reasons that were stated, the applicant, and in the interest of both, in the interest, in the concern, in the interest of justice, the order dated
24/4.
24/4/2024. So before that, the delay of
Two.
so, and it is also stated that when we are getting the instructions of the office is in Delhi, there's a delay in filing the application, considering the same, the delay of so and so days. How many days?
217.
2 months.
More than 70 days to filing the application is turned down, and consequently, the order dated so and so 24/4/2024 is set aside on the condition that the PW1's cross-examination shall be commenced on. It will be 1 day of distribution.
Yes, sir. Yes.
It shall be completed on 4th of February.
Ablaze. Yeah, must keep the PW1 present, Malad. That's on the same. On that day, you must keep the PW1 present.
That is my
Right.
I will.
Because many times he said he is not keeping well, he is not coming. That's what he was told many times. Ablaze.
Both the application gets disposed.
Ablaze.
Serial number 3.
Malad 3, Malad, R1, Malad,
Madhavan.
R1 is from Tamil Nadu, Malad is Coimbatore. He is died, Malad. I have made an application to bring his LRs to the case. Malad, that I have sent the notice on the Malad R1, Malad. Yes, Malad.
My lord, I appear for R4, my lord. I filed my memo of retirement on behalf of R4.
Malad, the postal come,
For R1 and R2.
Yes, my lord, but then R1 as on today is dead. I have filed the death certificate before the honorable court. So as on today, I appear only for R4.
When is that application?
Malad, I have made an application to bring the LR, Malad. There is an order by this honorable court, Malad. Yes, Malad. Notice was ordered, Malad. That notice which has been sent, Malad, the post government says that no such person, Malad. No such. Malad, I have to find out fresh address and I have to take fresh steps, Malad, for R1. LR of R1, Malad.
My lord, insofar as that memo is concerned, I had sent that by RPAD, that cover, my lord, I have filed it earlier. I'm just filing a memo in form for it. That cover has already been placed before the court. It has come back answered, my lord. In fact, the whereabouts of this person is not known again. Answered, my lord. It has returned answered. Yes, my lord. Cover is before the court. Those were my mails that I had sent to that concerned person. It has not bounced, but then there's no reply as such.
After the oil substance, the, yes, the oven is no more, the notice is ordered. On the last of, on the LR application, the court has already ordered notice, and the notices returned. Those are addressing, or address not known. What is that?
My lord, my lord, it was sent through a Tahsildar Coimbatore. My lord, Tahsildar has written a letter to us stating that only his wife is residing there, sons are residing in different places. But my lord, the wife also, she is not giving the correct address. She says that I don't know where my sons are residing. That is why, my lord, my lord, my lord, the Tahsildar report only says that wife is only residing, sons are residing different places. So I could not find out the correct address of their sons. My lord,
It is also the legal representation
Yes.
of R1. And as far as she can be, as far as that R1A
I,
is concerned, it is.
my lord, I will take fresh steps, my lord, including mentioning his wife and sons also.
Only the wife is residing and she is not aware of the whereabouts of her son.
My lord, sorry, my lord, sorry, my lord. The report says it was reported that only wife of the deceased called.
In fact, this honorable court had directed the Tahsildar to file it.
One is residing in United States, my lord, that is what.
Memo retirement. 444. Our application.
Long back, I think.
Yes.
After what happened?
My lord, now I have to take a fresh steps, my lord.
How it will take.
Yes, my lord.
As to the festival report, the wife is not cooperating, and the property that property also stands in the name of the son. And in your general elections in Tamil Nadu, the festival purpose more time in gathering and furnishing the further details. The council summons taking fresh steps. Matter on when do you want?
My lord, next week, my lord, 2 weeks, my lord, by the time I'll find out the address and.
What about your memo of retirement?
4, my lord, R4. R4, my lord.
The council is very, so the responding number. 4. that R1 is no more. And for R4, there is no contact on several years. And he has registered everything. And also, that he's giving up the Bakalan and it is returned as no such existing. So, he's committed to retire. And then he feels and the movement of these things to R4.
Serial number 4, even.
My lord, 4, my lord. This LR of R2, my lord, address is in Colombo. Address is in Sri Lanka, my lord.
You're referring to 3?
My lord, 4.
Yes.
My lord, R2, my lord, expired, so LR5, I have made an application for bringing LRs to the R2, my lord. My lord, the address is shown as Colombo address, my lord, that is Sri Lanka. My lord, your last, now I have sent the notice through embassy. My lord, item dispatched in Colombo, no reply has been come. My lord, interesting, my lord. Your lordship may kindly see the cost list, is the cost title. My lord, R3, R4, and R9 are staying in the same address. R3 and 4 are being represented by a learned counsel. At least she can tell.
Please, my lords, I'm on record for R3 and R4. My lords, I had earlier made the submission as well that I have no instructions from R3 and R4 in the matter. When the matter got relisted.
What's the relation between you said R3?
My lord,
R3.
You represent R3 and?
My lords,
4,
original.
9.
No, I represent R3, R4, and R7.
Who is our representative?
My lord, R3 and 4, my lord, learned friend is appearing.
He's appearing.
Yes, my lord. R9, my lord, is the same address, my lord. If even 3 and 4 and 9, same address. My lord, he leaving 9, my lord, whoever is not appearing, my lord. 3 and 4, who is in the same address, my lord, my learned friend can.
My lords, I had made a submission almost a year ago, and
Yes,
which
ma'am.
was reiterated as well. That
Yes, ma'am. Yes, ma'am.
Yes. What happened to the notice to him?
My lord, R9 also is being represented by one DS legal, my lord. It's there in the cost list.
Ma'am, this R2 has the same address as R3, R4, and R9. So, my lords, R2, we are trying to find the latest address. If the counsel for R3, R4, and R9 can tell us the whereabouts and the relationship, we can.
As per the cost title, R2 is also residing in the.
At the same address.
What is the relation between all this?
My lord, that relation is not visible through the documents I have.
Let's see.
But my-
the cost title.
Yes.
So you represent 3, 4, and 9.
No, my lords, 3, 4, and 7.
No, 9 is represented by some other advocate.
Yes, ma'am. Yes, ma'am.
Yes, my lord.
DKS legal, my lord.
My lords,
DSK.
I also used to represent R1, but who has expired in 2017. I had filed a memo with the details of his demise.
File in respect of one,
And two.
Two.
1 and 2, my lords.
no. Two died, one died,
Ma'am, my lords, both R1 and R2 have deceased, my lords.
R1 and R2.
R2, yes, my lords. Now, my lords.
My lords,
we had two-
R1 expired in 2017. A memo was filed by me at that point of time.
My lord, since R1 was being represented, we filed the application with regards to R1 for LRs of R1. Regarding LRs of R2, we need to get the latest address. That we have not been successful to get them. That's why.
What happened when you sent the notice to this address? As furnished in.
Well, it is not returned, my lord.
Not returned, my lord.
It was sent through embassy.
Embassy.
When was it sent?
My lords.
13/3/24.
My lords, we had first written on 12/9/2019. And thereafter, we have sent reminders in 21 twice, 22 twice, then 24 once. And 24 also twice, my lord. So, my lords, still we are not able to trace them. There is no reply.
What is the response from the embassy?
No response, ma'am.
Then what are you proposing to do now?
My lord, that's what we were expecting if the persons who are being represented and living at the same address. I understand.
File wakalat karne.
No,
I am not saying that, my lord. If the people who are being represented are living in the same address, if the council can be requested to ask them to give the details, that will help. Otherwise, my lords, we have to.
if they give
again-
that,
My lords, I had made the submission almost a year ago. I have no instructions from R4 and R7. Sorry, R3 and R4. Ever since these matter has been relisted a year ago.
The council, you're representing the 3 and 4, who are residing in the very same address as that of 1 and 2.
My lords, I have no contact with R3 and R4 for the last 2 years since the matter has been relisted again. I had informed this honorable court earlier as well. I may be on record for R3 and R4, but I have no contact with them.
The deceased respondent number 1 and 2. This is not on only one.
6 weeks, my lords. We'll again try through embassy, my lords.
Seal number 5. Case
paper the
Mahadevan
official liquidator matter, your lordship.
Kumar.
Lord, this CA 65/2015, which is filed by the official liquidator under section 454(5), Lord. Lord, by an order dated 4/7/2024, your lordship may kindly peruse that for a moment. 4/7/2024, my lord. There was a direction by this honorable court, please. Lord, there was a direction by this honorable court to the respondent number 2 and 3 to rectify the defects by next date of hearing, which was raised in the statement of affairs by the official liquidator. Even earlier to that, my lord, we have issued a notice twice, my lord. It was on 28/11/2019 and 31/5/2022, asking them to rectify the defects which are raised in the statement of affairs. Even despite it was not returned, and even despite the order of this honorable court on 4/7/2024, they did not rectify it. And bailable warrant is issued against the A2, my lord. And there was a specific direction by this honorable court to be present him at all the date of hearing. Even despite he did not, my lord. And thereafter, my lord, there is a direction of this honorable court to file an affidavit before the official liquidator with all his address, current address proof, email ID, contact numbers. Please, my lord. One Ajay Kumar is appearing, Lord.
Chief Kumar. Government advocate.
Please.
Serial number 6. Mahadevan for respondent.
My lords, I appear for R4 in this.
For R2, my lords, I appear for the official liquidator, my lord. In this CA, due to circumstances, I am one of the respondent and also one of the petitioner, my lord. Because there are two companies in question, Kingfisher Airlines and UBHL, which was a parent company of Kingfisher Airlines. Both have gone into liquidation. Though they were of different ranks in the suit, I represent both of them post winding up order, my lord. The CA 3 of 2017 is filed under 446. The 446, my lord, is a power vested under the company code once the order of winding up is passed. It prescribes two things, my lord. One is that if there are other suits pending in any other court, they will be automatically stayed and they can only be continued to be prosecuted if the court grants permission to prosecute under 446(2). This is with a view that during the pendency, after the winding up order, my lord, the OL can take control of the assets and sell them as per the provisions under the Companies Act, and thereafter distribute the proceeds to the creditors in accordance with Section 529 and 529A. So only in cases, there can be two cases, my lord. One is that a suit is filed against the company in liquidation, and one is that the suit is filed by the company in liquidation. In both cases, it is the obligation of the plaintiff approaching a court before to come before this court to take permission to continue prosecution. In this case, my lord, the applicant in the CA is UBHL. The application was filed before the winding up order of UBHL was passed, my lord. So at that time, the application was filed by the management and directors of the company. We have inherited this application as it is once the winding up order is passed. So post filing, I have become applicant, though initially I was not the applicant. One of the respondents in the matter is Kingfisher Airlines. Unfortunately, because of winding up order in that matter as well, I have become the person relevant for it. Now, my lord, under 446, in addition to continuing prosecution at the relevant court, there is an alternate power given to this court as well, where instead of permitting continuance before the trial court, the court can order that the matter be transferred to the High Court and the evidence and arguments may be concluded herein. In both these prayers are made in the alternative in the matter that was inherited by the official liquidator. The official liquidator now favors the transfer of matter to the High Court so that evidence can be recorded with the registrar CPC and final hearing can be done here. This is also more so because the value of the matter is quite high. It is in the range of about $200,000, which is several thousand crores. Hence, the request is just that there is OS number 6406, which is pending since 2012. 6406. Please. It is a multifarious suit, my lord. It is to declare certain corporate guarantees as non-binding, and it is in the alternative to pay approximately 1,431 crores by defendants 1 to 5. Please, my lord. Please, my lord. Yes, ma'am. If your lordship has the application. The plaint is at page 16 of the application, my lord. The prayers start towards the end, my lord. The Prayers would on 56. 56.
You represent which respondent?
Second respondent in the application. I am also a defendant in that suit. IAE. IAE Aero. Yes.
That's defendant number 1.
In the suit. Yes.
Who represents who?
I only in the suit I do represent 1 to 5. Yes. I represent the remaining one. 6 is also the, please.
So where is the relief that is sought?
Please, my lord, the alternate reliefs are sought, page 56, my lords may see the prayer. No, that is the, my lord, the prayer in the suit, my lord.
How many pages should be the judgment?
I'll let my learned friend complete, but I have a basic objection on maintainability of this application, which I'll raise.
The prayers A and B are of declaration and injunction nature, my lord. Prayer C is a money decree, my lord. Estimation of 2,000, 100,000, 200.
If
Ten.
this expired in the year 2012,
Please, my lord.
winding up was when?
February of 2017, my lord, for that is for the plaintiff. For the defendant number 6, it was a couple of months before November of 2016.
Yes.
It has still not reached the stage of framing of issues. Because of delays, I am unable to answer positions before 2017, my lord. Post 2017, because of the pendency of the CA, the present application, my lord, it's a please, my lord, it is the application, company application 3, my lord, filed, I think on 5/1/2017. The prayer in that is at page number 13. Prayer A is to permit continuing prosecution of that suit, which was stayed by operation of law. The second is an alternate prayer, my lord, which is favored by the official liquidator currently to have it transferred instead of prayer A, my lord. 446, my lord. May I be permitted to read the relevant sections, my lord? This is the old act, my lord, 1956. 6, my lord. Suit stayed on winding up order. When a winding up order has been made or the official liquidator has been appointed as provisional liquidator, no suit or other legal proceedings shall be commenced, or if pending at the date of winding up order shall be proceeded with against the company except by leave of court and subject to such terms as the court may impose, my lord. This is the power that is sought to be invoked for prayer A, my lord. Subsection 3, if I may invite your lord's attention to. Any suit or proceedings by or against the company which is pending in any court other than that in which the winding up of the company is proceeding may, notwithstanding anything contained in any other law for the time being in force, be transferred and disposed of by that court. This is the power I am invoking for the alternate prayer, prayer B, my lord, which I am now pressing that it be, because of the value of the suit, it may be better be prosecuted under the supervision of this court, my lord.
My lords, maintainability first. 2 facts I'll just lay before my lordships. UBHL, who's filed this application, it was wound up on the basis of my winding up petition, where I said that they gave me corporate guarantees, which when the time came, when it was invoked, they refused to honor. This court holds that yes, that is correct. The corporate guarantees refusal to honor them was prima facie failure to pay a debt and winds it up. Now, my lords, my learned friend is appointed based on lordship's order, this court's order, that the corporate guarantees ought to have been honored. Because they were not honored, a debt is not paid and UBHL ought to be wound up. The suit, the prayers lordship read, are to void those very corporate guarantees on which this court has already ruled prima facie in the winding up petition. In the winding up petition, your lordships have held that the corporate guarantees ought to have been honored. And the suit has been filed to void those very corporate guarantees. My lords, therefore, there's a clear issue there which lordships will have to deal with in detail if this application.
The prejudice that is caused to the defendant.
My lords, this suit ought to have been, in my humble submission, yes, which is after I filed my winding up petition 6 months before this suit, my winding up petition. They filed this, the UBHL filed this suit as a defense. This suit was put before this court when the winding up petition was being heard, saying this is a viable defense. This court has ruled in the winding up order that it's a suit which has been filed as a moonshine defense. It has no merit. This defense has been set aside by the court and winding up ordered on the basis that the corporate guarantees were valid and ought to have been honored. Now, my lords, to prosecute a suit where exact contrary stand is taken and by the OL who is appointed at the orders of this court after the finding on corporate guarantee, my lords, this application ought to be not considered. There is no question of continuing this suit any further, prosecuting this suit. Yes, that is, I'm placing it before your lordships.
No, instead of pending that suit before the court, before the civil court, right from the year 2012. No, you have an order in your favor, as you say.
Yes.
that in your winding up proceedings. Then it would be useful for you if it is before this court.
My lords, the Supreme Court in one matter, I'll place the judgment for you, has observed that when it is found that a suit has no merit, the plaintiff ought to be directed to withdraw that suit rather than use this power in 446, unnecessarily transfer it to the High Court, and then try to prosecute or later withdraw. My lords, that is, in my humble submission, a waste of judicial time to permit such applications where just for the sake of withdrawing a petition, a matter is transferred from the civil court to the High Court and then it is withdrawn. My lords may look into the merits of the matter, and lordships can certainly direct that 446 will not apply, power will not be exercised, and direct the liquidator to withdraw the suit. And I have a judgment to that effect.
That's just the
The winding up order, my lords. Yes. I have made a compilation of various orders passed by this court. Give it to him. My lords, the winding up order commences, my lords, at page 164 of that compilation. Yes. Lordships will see that there were multiple petitions which were connected. I am the first petition at page 164, company petition 57 of 2012, IAE. The submissions made on this company petition start, my lords, at page number 196. My lords, the petitioner company IAE, incorporated in Switzerland and having a permanent place of business in USA, has approached this court by way of the aforesaid winding up petition with the case that the petitioner manufactures and sells aircraft engines and related equipments, and it has leased a number of aircraft engines to KFAL, a subsidiary of the respondent UBHL, and inter-alia executed on 27/10/2010 an agreement called V500 rework agreement for maintaining so-and-so. My lords may see para 23. The respondent company UBHL executed two corporate guarantees. Guarantee 1 under repayment agreement dated so-and-so for USD $27 million, and guarantee 2 under the rework agreement dated 1/8/2011 for USD $18 million, which they refused to honor. These agreements, in 6 months later, the suit which was filed, they are saying, declare these agreements as void. Now, my lords may find, so the submission made was that, therefore, when the corporate guarantee was invoked, they refused to honor it. And when the winding up petition was, notice was issued, they said they will not pay. My lords, the submission made in defense, I will just point out to your lordships, was at page 253, para 97 onwards, 91 onwards. Page 255, my lords may see. As a result, the respondent company has been constrained to file a suit. Now, the suit which is ought to be page 255, para 92. Now, this suit is discussed, which today my learned friend seeks to transfer. As a result, the respondent company has been constrained to file a suit in the City Civil Court bearing OS number 6406 of 2012, inter-alia against IAE, that is against me, and its aforesaid constituent joint venture partners. From a mere perusal of the plaint, it is clear that the respondent company has a substantial claim in excess of 1,500 crores. These are submissions being made on behalf of UBHL, which is far in excess of the alleged debt claimed by the petitioner company to be alleged to be due and payable. Since by an order dated 18 November 2016, Kingfisher has been ordered to be wound up and Kingfisher Airlines is a defendant in the suit, the respondent company has filed this application is then discussed. My lords may see this court's finding on that defense. The findings on that particular defense is at page 344, para 175 onwards. That a suit has been filed, therefore there is a dispute to the debt. Page 344, para 175. May I? 175, my lord. The defenses put up by the respondent company UBHL to contest the present set of winding up petitions against it as noted above are not worthy of acceptance, and they do not inspire any confidence that such defenses may succeed in law. On the other hand, this court finds a tinge of doubt and mischief, cavalier manner, lack of bona fides, and finds them to be too far-fetched without any solid foundation, and it is difficult to see such defenses to really succeed either before this court or at an appropriate forum where they may have been raised and instituted as legal proceedings against the petitioning creditors. So, my lords, the defense that in response to the corporate guarantees, I have filed a suit to declare the corporate guarantees as void. Prima facie, this court notes that there is no bona fides in that defense. The court then goes on to say that failure to pay the corporate guarantees was a default. It is an admitted debt which you refuse to honor, and therefore you ought to be wound up. Much water has flown under the bridge since then. My lords, this order was 7 years ago. It was upheld by the division bench of this court. It was upheld by the Supreme Court. Today, if my lords may see, if this suit is allowed to be prosecuted, and what is the result of this suit being allowed, the entire winding up proceedings will have to be set aside, my lords, because the winding up was passed on the basis of this corporate guarantee. How can that suit be permitted to be prosecuted today is my first submission, my lords. Second, my lords, is on the maintainability of CA3 in another different manner. My friend says that CA3 was correctly filed when Kingfisher was wound up, but UBHL winding up order was not passed. My lords, Kingfisher was wound up cannot be the basis to file this application. 446 says, I agree, it says if a suit is pending against a company. But my lords, those words against have to be read in more than just a formal manner. If there was a prayer sought against Kingfisher in the suit, I would agree that a case is pending against Kingfisher within the meaning of 446. The prayer is only sought against me. Kingfisher is made a formal party to that suit. The purpose of 446, my lord, Supreme Court holds, is to make sure that the assets of the company are not frittered away in a litigation which is frivolous or undefended. How can assets of Kingfisher be frittered away in a litigation in which no relief has been sought against it? That is my next submission, my lords. That there is no prayer against Kingfisher. Formal party. Because the prayers, if lordships remember at page 56 of the application, is only against me. That the corporate guarantees given to me should be declared void. And plus, it's not an alternate prayer for money, as my friend said. It is an additional prayer. That first declare the corporate guarantees as void, and second ask me to pay him 215 crore rupees. So, my lords, there is no prayer against Kingfisher. To that effect, my lords, 446 does not apply even in that context. Kingfisher was a mere formal party. And I'll place on record judgments which show that 446 is only to be exercised when any interest of the company is at stake, not as a formal party. So, my lords, in that sense, this application was non-est at the very beginning. It need not have been filed at all. The suit could have been prosecuted at least till UBHL was wound up, is my submission. Respond to the submissions in reverse order. No, one more submission. Insofar as Kingfisher prosecuting the matter, Kingfisher entered appearance in the suit, never filed its written statement. So, it is not even contesting that suit at that point of time till 2017. So, my lord, no relief is sought. So, my lord, where is the question of transferring a case against Kingfisher just because Kingfisher is made a pro forma defendant there? I will just place on record 2 or 3 judgments on the objective of 446 Supreme Court and High Court. Because the first judgment is in the context of 446 itself. Supreme Court 2006 4 SCC. I may invite my lord's attention to para 18 onwards of this judgment, which is at page number 8. If I may, my lords. The object of 446 is not to cancel, nullify, or abate any claim against the company. Its object is to save the company which has been ordered to be wound up from unnecessary litigation. Page number 8, para 18, the last para at the bottom. Page number 9, my lords. Okay. The object of section 446 is not to cancel, nullify, or abate any claim against the company. Its object is to save the company which has been ordered to be wound up from unnecessary litigation and from multiplicity of proceedings, and protect the assets from equitable distribution amongst its creditors and shareholders. When no relief is sought against Kingfisher, where is the question of protecting his assets in that litigation, in the suit? None of his assets are at stake, I would say. This object is achieved by compelling the creditors and others to come up to the court, which is winding up the company, and prove their claims in the winding up. There is no claim against Kingfisher in that suit. So therefore, my lords, this squarely applies. For this purpose, all suits and proceedings pending against the company, which are also stayed subject to the discretion of the winding up court to allow such suits and proceedings to proceed. When a winding up order is passed, the effect is that all affairs pertaining to the company in liquidation, including all suits, proceedings by or against the company, come within the control and supervision of the winding up court. The winding up court has to decide whether it will let the suit proceeding to continue in the court where it is, or it will itself adjudicate the suit or proceeding. Thus, under 446(1), the winding up court only decides about the forum where the suit is to be tried and disposed of, provided some asset of the company or interest of the company is at stake. Now, my lords may see para 20. It is now well settled that if any winding up order is passed during the pendency of a suit against the company, and if the suit is continued without obtaining leave in spite of that bar contained in 446(1), the decree passed is only voidable at the instance of the liquidator and not void ab initio. Now, my lords may look at this. If today the suit had continued and a decree had been passed, what decree would there be against Kingfisher? No decree. The decree will only be against me. So therefore, my lords, this observation of the court is relevant even to that point again, that at best a decree could have been passed only against me, not against Kingfisher. So therefore, my lords, there's no question of exercising this power to transfer. In fact, where such decree has been passed against the company and others, the only person who can avoid the decree on the ground of non-compliance on 446(1) is the official liquidator of the company and not the other defendants. I could not have said they could have continued the suit, obtained the decree. I would not have had that defense. Only Kingfisher would have had that defense if the decree was against them. By their own prayers, there could have been no decree against Kingfisher in this matter. I'll just skip 2 lines, my lords. I'll go to one sentence starting various alternatives in the same para 19. Various alternatives are possible when a suit gets so stayed. The plaintiff in the suit can move an application under 446(1) of the Act, and when the leave is granted, proceed with the suit. If the leave is refused, the suit may be transferred to the company court for being tried and disposed of under 446(2)(a) of the Act. The plaintiff may also file an application for transfer of suit to the company court for disposal under 446(2)(a). Alternatively, the plaintiff may get the suit dismissed with liberty to make a claim. Even if the suit is proceeded with without obtaining leave of the company court, either not being aware of the order of winding up or ignoring the provisions of 446(1), the resultant decree will not be void, but only be voidable at the instance and option of the official liquidator. So, my lord, these findings all show that the power is to be exercised only when there is an interest of the company at stake. The suit, no prayer against Kingfisher, I would reiterate. Therefore, no interest of Kingfisher is at stake in this suit. So CA3 at least, my lords, cannot be allowed on that basis that just because Kingfisher is wound up, the suit should be transferred.
May I make my submissions, my lord?
No.
It's in the next year.
Yes, my lords. Yes. My lords may see the next judgment at page 13 onwards. Para 14 of that judgment, my lords. para 14 of the judgment. It's a judgment of the Madras High Court at page 24. Para 14, I'll read, in fact, my lords. Para 14. Upon careful consideration of the judgments referred above, section 446(2), which is, my lords, the transfer provision, and the findings of the learned single judge, we agree that the decision of the learned single judge that in the winding up proceedings of a company, claim by or against the company alone can be decided. So, my lords, the matter in which this application is filed is the winding up petition of Kingfisher. Madras High Court says only claims by or against the company can be decided under 446(2). The suit has no claim against Kingfisher. Third party claims against a bidder in the auction cannot be decided by the company court. UBHL has filed a suit against me. I am a third party. So even that observation applies, my lords. UBHL's suit, when filed, was against effectively me, not against Kingfisher, because there was no claim against Kingfisher. So therefore, my lords, even this statement keeps this suit out of the proceedings of 440, out of the scope of 446. Yes. I'm at the plaint, my lords. Page 56, my lords, will find the prayer. Para 94. If I may, my lords, read it. The plaintiff, wherefore, the plaintiff prays that this honorable court may be pleased to pass a judgment and decree against the defendants for the following relief. A, that this honorable court may be pleased to order and declare that the corporate guarantees dated 10 November 2010 and 1st August 2011, issued by the plaintiff in favor of defendant number 1, stands vitiated and are void, non-est, and of no legal effect. I pointed out these two very guarantees were dealt with by this honorable court in the company petition. Prayer B, that this honorable court may be pleased to permanently restrain IAE by a permanent order and injunction from taking any further steps to enforce the corporate guarantees dated so-and-so executed by the plaintiff in favor of defendant number 1, and or take any further steps to enforce any judgment, order, or decree that may be passed. Yes, my lords. Defendant number 1 to 5, pleased to order and decree. Defendant number 1 to 5. Kingfisher is defendant number 6. Yes, not 5. My lords may see the array of parties is at page 16 and 17. Kingfisher is 6. So he only seeks prayers only against me. No relief.
Something like sixth respondent is mentioned at prayer number D.
Prayer number D may see, I'll just read it out. I'll just read the full prayer. That this honorable court may be pleased to order and decree that defendant number 1 to 5 do jointly and or severally contribute or indemnify the plaintiff in respect of any and all claims that may be raised against and or devolve upon the plaintiff under the various corporate guarantees executed by the plaintiff on behalf of defendant 6. So he says the corporate guarantee was given on behalf of D6. If anyone makes a claim against me, I should indemnify UBHL. So even defendant 6 is mentioned, but it has no role to play in that prayer. The prayer is still only against me. That if anyone makes a claim against UBHL, I should guarantee and indemnify them to that extent. Yes, my lords, back to the judgment. I was reading, my lords, para 14. So I was saying, my lords, third party claims against a bidder in the auction cannot be decided by the company court. I am a third party here, my lords, for the purposes of this suit, which is filed by UBHL against me. Our proceedings are not subject matter of the company court. The power to decide on incidental claims must also be related to the winding up proceedings. So, my lords, incidental claim, if any, should first of all be connected to Kingfisher. My lords, by me on 26th March 2012. I'll, my lords, give just 5 or 6 dates to my lordships. On 26th March 2012, I filed company petition 57 of 2012 against UBHL. Yes. On 5th September 2012, UBHL files this suit, OS 6406 of 2012. On 18 September 2012, company petition 214 of 2012 is filed against Kingfisher Airlines. On 18th November 2016, company petition 214 of 2012 against Kingfisher is allowed. Winding up is ordered. Company petition 214 of 2012. Yes, which was filed just on the previous date which I mentioned, which was filed on 18 September 2012. Yes, 18 November 2016, winding up ordered. January 5, 2017, this application, CA number 3 of 2017, is filed before your lordships. And February 7, 2017, my winding up petition, which was company petition 57 of 2012, is allowed and UBHL is directed to be wound up.
Earliest the winding up order in February 7.
Yes.
It is Jan 5, 2017.
No, November 18, 2016. Jan 5, 2017 is the filing of this application. These 6 dates, my lords. Yes, my lord. The power to decide incidental claims must also be relating to the winding up proceedings. Just because the second respondent is an auction purchaser, it cannot be said to be either the debtor or creditor of the company falling within the definition of claim. So, my lords, because the winding up was filed in the context of Kingfisher's winding up, this application is sought to be filed because Kingfisher is wound up. I have no claim against Kingfisher. Kingfisher has no claim against me. UBHL also has no claim against Kingfisher. Therefore, my lords, this proceeding, the suit is entirely out of the scope of any order under 446(2). I'll continue reading, my lords. I'll read para 15 now, my lords, in fact. Insofar as the judgment relied on by either side are concerned, in 1985 SCR 1 511 cited by both counsels, the Supreme Court clearly lays down the proposition that claims can only be relating to the company under liquidation. So, my lords, again, going back to my original point, that goes. My lords may see the last 3 lines of para 15, because this goes to another point without prejudice submission, which I'll make. The suit is filed saying that the corporate guarantees were obtained by fraud. Therefore, they should be declared void. Now, my lords very well knows any trial which involves the proof of fraud requires extensive evidence to be led. My lords, proceedings under 446, as my learned friend said, the official liquidator wishes the proceedings to be transferred, will be summary in nature. His application says so. Supreme Court also says so. That proceedings under 446 will be summary in nature, without prejudice to my first contention that the application is not maintainable. A suit which alleges fraud and serious fraud, on the basis of which corporate guarantees are sought to be voided, cannot be tried in a summary manner. My lords may see the last 3 lines of para 15. Insofar as Dr. Mahesh Batra's case is concerned, it is in fact against the appellant. In that case, the Company Law Board has held that disputed questions cannot be decided under the summary jurisdiction. Continuing to para 16, my lords. Therefore, we come to an irresistible conclusion that the role of the company court while dealing with winding up proceedings is restricted to claims by or against the company in liquidation. In the present case, except for the fact that the demand drafts were issued in favor of the official liquidator, there is no nexus between the appellant and the company in liquidation. There is also no privity between the appellant and the second respondent. Here also, between UBHL and Kingfisher, what document has been placed on record to show that there is any privity between them? The company court in the course of winding up proceedings cannot be converted to a writ court under Article 226 of the Constitution or exercise the inherent power under the CRPC. Because therefore, this again goes to my submission that there being no prayer, no privity, no claim against Kingfisher, this application was non-est at the very beginning. The suit could have indeed continued without this application having been filed. So therefore, my lords, there was no automatic stay of the suit insofar as the parties are concerned. It was a misconceived fact based on which this application has been filed, and therefore the application ought to be dismissed. My lords, the last judgment. of Sudarshan Cheats. Relevant page at 33, my lords. Para number 8, my lords, at page 36. Yes. Before we advert to the construction of 446.2, my lords, I may just take my lords to the next page where just continuing in this para about 10 or 12 lines from the bottom of para 8, from where para 8 ends. It says now at a stage. Now at a stage when winding up order is made, the company may as well have subsisting claims, and to realize these claims, the liquidator will have to file suits. To avoid this eventuality and to keep all incidental proceedings in winding up before the court, which is winding up the company, its jurisdiction was enlarged to entertain petition against others for recovering the claims of the company. In the absence of provisions like Section 446(2) under the repealed Indian Companies Act 1913, the official liquidator, in order to realize and recover the claims and subsisting debts owed to the company, had the unenviable fate of filing suits. These suits, as is not unknown, dragged on through the trial court and the courts of appeal, resulting not only in multiplicity of proceedings, but would also hold up the progress of the winding up proceedings. To save the company, which is ordered to be wound up from this prolix and expensive litigation, and to accelerate the disposal of winding up proceedings, the Parliament devised a cheap and summary remedy. Summary remedy is the key again, my lords. By conferring jurisdiction on the court winding up the company to entertain petitions in respect of claims for and against the company. Only in respect of claims for and against the company. This was the object behind enacting 446(2), and therefore it must receive such construction at the hands of the court as would advance the object and any rate not thwart it. No claim against Kingfisher, my lords. Therefore, all judgments clearly say that if there is no claim against the company, the 446 does not apply. And therefore, this CA number 3, my lords, should not be allowed. That is my submission, my lords, in effect.
May I respond, my lord? Several submissions have been made, my lord. With respect, I'll just bring back to this court to what can be done in 446 and what is it that is being argued. If my lords feel the need that I address the arguments on specific merits of the case, I'll address those as well, my lord. My preliminary submission is on today's hearing under this CA, there can only be two things, my lord. It can either be a transfer of the proceedings here or permission to continue there. In either case, my lord, either if it is transferred here or permitted to continue the case there, all the submissions that were made subsequently on merits, including with respect to whether it was the same debt under which COP was allowed, whether that debt this court has already ruled upon, is for the judge who's continuing trial in that matter to consider and answer, my lord. If it were the opinion of this court that it is the High Court, your lordship, once it is transferred, this court can decide upon it, my lord. If for any reason transfer is not thought fit and permission is granted there, the same application can be moved there for dismissing of the suit at the threshold, my lord. Now, this is an original suit which is not of summary in nature, my lord. The judgments relied upon by my learned friend towards the end of the submission, where he relied upon the phrases that 446 is a summary proceedings, is not with respect to the cases that are transferred. A case which is an OS, when it is transferred, will not automatically become summary proceedings, my lord. It will still be bound by CPC. As he has read in the first judgment that he pointed out, it is only the place of trial that this court is deciding under 446. The nature of the underlying proceedings will not become summary just because it is transferred here or continued there. Provisions of CPC will apply to trial of suit. It is just that it is now being tried in the High Court. There will no shortcuts be taken ever. There will be no procedure that is cut down. It is only the place and the court which is deciding will take into consideration the relevant provisions and rule accordingly. And this will not, though the application that your lordship is currently hearing, the transfer application is summary. When it is transferred, the case will not become summary. That is the submission that I'm putting forth, my lord. That is the reason why I say that all the arguments on merits are to be considered once this order is passed. Now, because CPC applies for OS, if their argument is under Order 7, Rule 10, Order 7, Rule 11, whatever application it is, to say that this suit cannot be continued, it has to be heard once this court decides where it has to be heard. Right now, we are deciding where it has to be heard. Whether it has to be heard, whatever application they may file, we will entertain that. We will file necessary pleadings if required, and such proceedings can be answered then and there itself. May I continue to address on merits, my lord? If it is just this, I will conclude it here. If your lordship considers this, then yes, ma'am.
Not say, it's not maintainable, it has to be dismissed. Under the scope of this application, either you have a remedy before the court or before this court. Even whether such a suit is not maintainable for rejection of claim or whatever it is, you have to come up with an application. If all the matters are pending before this court, if those matters are before the court, the very same argument, if you advance before the court, it would be in your interest.
Malaz, I'll make a submission. My learned friend says that the court has no option but to grant one of his reliefs, that either transfer the suit or permit the matter to go on. My submission is that 446 does not apply at all. That's what I said, my lords, that when this application was filed, there was no claim against Kingfisher in the suit. Yes.
What is that your client wants?
My lords, I am a different.
There should be some logical conclusion.
Yes. Yes.
So if those pending proceedings are transferred to the High Court, and before the High Court, you can find whatever application you want to, and it will be decided. Why should it be pending before that court when the winding of proceedings of both the companies are before this court? It is not on the merits of the matter. By allowing this application,
yes,
court would not be giving any finding with regard to
merits of
whether such a suit is maintainable or not. That it is for you to
yes,
file an appropriate application. So when everything is before this court, everything with related to UBI and all is before this court, it's easy for you.
My lords, I'll make 2 submissions in that. Yes.
The merits of the matter.
Yes.
Now, even before that court also, before the court where it is pending, you have to submit all these, you have to put forth all these arguments.
Yes,
and
my lords.
ultimately you have to know your ultimate motto would be to get the suit dismissed. Why not before the company court?
I will respond, my lords. That application to dismiss the suit is pending before a coordinate bench of your lordships today in CRP. I have filed a civil revision petition challenging the maintainability of those suits. Those applications are pending before a coordinate bench of your lordships. It's not pending in the civil court, it's pending here now. Today it is pending. I mean, it's pending, it's not listed today, but it's pending before this court, challenging the maintainability of those very suits. My lords, 2017, I believe, my lords. So I challenged it on the grounds of jurisdiction, etc. at that point, not on these grounds. The court said that these are triable issues.
Can't be decided.
These are triable issues. I've challenged that. Those proceedings are pending before your lordships. CRP number, my lords, 290 of 2016. And some connected matters. 2016, civil revision petition. Because my Order 7, Rule 11 was not allowed by the trial court.
In that case, also the rectification was filed, before application is rejected.
My lords?
Again, is that also rectification is filed before this court, not a CRP?
No, my lords, if a 711 115 would apply of the CPC, because if the 711 had gone the other way, the suit would have ended.
Would have been under, it's a first appeal.
It's
Correct.
a first appeal.
So because it was not allowed.
It will come, rectification will be filed under 227 only.
May I make one,
Yes.
just noting, my lord, this is a second round of same arguments my learned friend is making. The CRP is of 290 of 2016. I am assuming that the orders will be passed somewhere in the year 2016. And all the arguments on jurisdiction meant.
No, these arguments are not made there.
Because all those divisions are before me.
Please,
So
ma'am.
that at least that matter also.
It will be
Civil
CRP.
revision, my lords, it is not a writ petition. No, my lords, whenever in,
There's nothing pending for the trial court.
my lords, in Bangalore, at least, we, whenever a 711 is rejected, we file a CRP.
There's an Andhra, everything is-
Yes, my lord.
Either it is under 115 or the 227.
Right.
There could be any repetition. So your case, by virtue of that application, your suit is still, their suit is still pending. So it has to be necessarily, and it will not be under 115.
I'll look into it, my lords, whether it should have been a 227 or 115, my lords. But my lords, going back to the issue of allowing this application, the first contention still remains. In respect, leave the merits aside, my lords, that
Your argument still agree that this application needs to be allowed.
my lords,
So it
I
has to
would,
come before this court. And whatever application that are not pending, it will be connected with this application.
no, my lords, my only lordships may consider that 446 cannot apply where no relief is sought against Kingfisher.
There is a court constituted, the company court.
Yes.
And all both the binding up orders are there in respect of UPIL and as well as
Kingfisher.
And everything is pending before this court. What is the big reason whatsoever it is that it should be pending there? No adverse orders, you can't, either it is before the civil court or a high court, it shouldn't make any difference to you.
My lords, my only,
As far as the proceedings as is rightly put submitted by him, it is not as per the CPC only the proceedings will be conducted even before a company court or recording of evidence and everything will be done. It is better before the high court. In spite of all the matters on the merits and on the applicability of 446 or whatever you are submitting.
yes, my lords.
So it appears to be very.
May I be heard on the merit? I would, if your lordship,
That the matters be and whatever it is, whether your objection of paying and everything, it will be done with.
if your
Yes.
if your lordship indulges me, I'm happy to submit on merits as well, my lord. If it is, if the submissions are being noted, I would request that my submission also be noted because these are even if the matter is transferred, it will still not be disposed of in the way that my learned friend wants. I can make those submissions as well. In the interest of time, because it is not related to this matter, I have referred, please.
I'm not indicating something.
Please, ma'am.
To happen when once we contest here.
Please, ma'am.
Whatever it is, you cannot have any.
Please, that is my first. Grateful.
It is before the high court. I'll record your submission. Please come.
My lord, may I request, it may be a common order in both the petition, both the applications listed.
I don't have, I've not served with the other application. I don't know what the other application
Okay,
is.
it will be,
It is up.
it is 434, my lord.
They will take notice.
No, we are only.
I don't.
6. Item number 6. Next is.
434, my lord.
What are the objections on 432?
My lord, I'll, it is, I think, copies to be served, my lord.
And where is the other application you are referring to? Where is it? Which is the other one he's referring to? 432. Oh, in that, I think you have to serve papers on it.
It is the same prayer. If this is disposed of transferring, my lord, that may be disposed of as infructuous. It's the same. Please, my lord,
4 copies on him.
please.
The,
I'm serving it right.
in CA number 434 of 2024, the old shall comply with the office objection. Objections by 24, this is matter on 29. That is CA number 434.
I am serving the copy.
And there are some other also. Cost title to be corrected.
Please, my lord, I'll do.
To
I will do that.
sign, provision of law to be stated
Please.
correctly. There are so many.
Please, my lord, will do.
CA number 30/2017. Oil has 590. Section 456. The company side. The original was number 6406 of 2012, pending on the file of the city civil court bylaw to this court. It is stated that the United Breweries Holdings Limited had filed a suit against the respondents 126, seeking the following reliefs. At page number 52, extract on the page. The United Breweries Limited was ordered to be wound up by order dated 7/2/2017, passed in company petition number 57 of 2012, and others, the official liquidator attached to the High Court has been appointed as liquidation of the company. The virtual section 449 of the Companies Act. This suit is filed prior to the winding up order. That is voice number 6406 of 2012. And the sixth defendant in the suit, Kingfisher Airlines Limited. And winding up proceeding, winding up order was passed on 8th November 2016. Even in respect of that company, the official liquidator is appointed as the company. The order of the binding of 2017, is quoted as the official liquidator to administer and take charge of all the affairs of the company in liquidation. In fact, the directive is clear in all matters, filed before the court. As now the present application came to be filed, stating that in respect of both the United Breweries and Kingfisher, the court has already passed the winding up powers in the official liquidator appointed. In the interest of justice, the matters may be as per section 446 2A and B. The matter will be transferred to this court. It is also stated that the suit is pending. Though the suit is of the year 2012, it's still pending for the city civil court, and it is at the stage of calling for summons in council, appearing on behalf of the official liquidator, subjects exercising the power of the suit will be transferred to this court, which then council appearing on behalf of respondent number 125 submits that on his application.
Those are only for R2 before your lordships. I have only filed wakalat for R2.
R2, yes.
IA.
So what about the other, you will not be representing them?
No, my lord. I believe my friend is on VC.
My lords, I appear for R4 in this.
You appear for?
R4, my lords.
Promote Nair.
Then
I'm-
who appears for what? Who appears for one? For Alpha's side?
I think so, my lord.
R1 is my friend. Kingfisher.
Please, my lord, R1 I appear, my lord, for Kingfisher.
No, not R. One is not in the.
My lord, in the dictating order, my lord, I think your lordship has a different CA. Your lordship should have, but facts are same, my lord, there would be no change.
Respondents are.
Change, my lord, that is the reason. My lord, I represent,
International Aero Engine.
please, that is respondent number 3, my lord.
No, one.
Aerotron, in the copy that I am served, my lord, the first respondent is Aerotron.
One is the official liquidator, Kingfisher Airlines.
In the copy that I have, my lord, I am respondent number 2, my lord.
One.
Official.
Please,
Something you have, some white thing has. been
please, my
there.
lord, maybe that, please.
Made one as official liquidator, Kingfisher Airlines.
I represent that, my lord.
Two you represent.
I represent.
Three Rolls Royce.
More instructions. I don't have.
And what is?
My lords, I'm for Rolls Royce. So, my lords, in my copy, my lords, there was R4. But, my lords, here I believe R3.
And again, he has changed everything.
Please.
Yes.
From white to the.
Yes. Then, my lords, I'll appear for R3.
Rolls Royce.
Yes.
Project with me a division of United Technologies Corporation. What happened to the?
My lord, I think they were served, my lord.
They need to look into this first.
Please, my lord,
Otherwise
appreciate
it's
it, my lord.
the Waste of time.
Please, my lord.
Sergeant John for R1 and R2. BN Murthy Associates for R4.
Serial number 5, my lord.
7, my lord.
Pramod Nair for R4. Then 5. Japanese Aero Engine. Then again, there are other two respondents.
Please, my lord.
But I don't think served on them or not.
My lord, I'm unable to answer, my lord, because these I have inherited. I have become the applicant post winding up, my lord. So I do not have the answers, my lord. If I appreciate, my lord. CA3 was also filed by the directors before winding up order was passed in UBHL matter, my lord. 2 months later, that order was passed.
Expect from the oil is.
Please, my lord.
Before we hear any mark on the manuscript.
Please.
First of all, whether the first service.
Please.
To respondents is completed or not.
Please.
Otherwise, like, will be.
That is for 434, sir. He's talking about 2017. It's not the same question, it is a different question. You.
Respondent number 3, 5 and 6. Somebody has then notice.
It's not.
Notice that or not? Then why it is written in the audio order 3, 5 and 6. exactly the critical point.
That is why in my opinion, my lord, it has been dispensed with and not noted, my lord. Otherwise, the non-service is noted on the right side of the cause list, my lord. If I may invite your attention to serial number 1 or any other serial number, my lord, they note. They would have appeared, my lord. Please, my lord. But have not appeared. Please, my lord. There may also one other reason which I can guess, my lord. It may be that they are placed ex parte in the OS as well. I'm not sure, my lord. That is why it may have been dispensed with, because I do not have those records. But before,
Placing them ex parte, only the summons date.
please, my lord, but at the time when this was filed, my lord, 8 months of proceedings. Please. Please, my lord, with I appreciate, my lord. This action may have happened before OL took charge, my lord. That is why I'm saying those records are not with me. From the time that CA was filed in January till February, the council is the council of the company of the former management, my lord. Do you know?
Dependents, respondents are unconnected. But all must be one and the same company.
They had all, for the purposes of supplying engines to Kingfisher, they had all formed JV.
You represent them in the.
I represent them in the suit.
Then we'll tell him, we will tell the official liquidator to serve notice on the council appearing before the trial court on behalf of the defendant. That will serve the purpose. And we'll take it up because you are the one, you are here. So you will serve notice on you. And we'll hear this matter next Thursday. The respondents. One is represented by the official liquidator, 2 is represented, 2 and 3 are represented by the council. In respect of 4, 5, and 6, the official liquidator, so the answerments on the
If my
council.
if my friend can take notice orally, my lord, it will save us some time. The long stand.
So the notice today itself on the council for the on the council appearing before the trial court. This is matter on Thursday as part on the top of the list.
31.
But I request you to so
Please.
all the matters, whether the notice is served or not served.
Oblige, my lords.
Let's not waste the time on this. Yes.
Serial number 7. Sutika Raghavan for applicant. Liquidate Mahadevan for OA.
I am the applicant in this case, serial number 7. Week, I am concluding my arguments and putting my written arguments also, answering the objections raised by the.
I am for the company. Filed by the ex-employee of the company. He was dismissed for my lord for some pitfall my lord in 2000. He was not filed any petition or he is not challenged that. And the company came to be ordered to be wound up in 2002, my lord, and the government company. And 2016, my lord, the government want to revive the company because the company is having some land, my lord, used for public purposes. So we come up with your lordship and the respondent for my lord passed an order for recalling the winding up order and permitted the company to utilize the land for the public purpose. And this present employee, my lord, he was filed earlier one repetition, I don't know, 2016, that was dismissed by the responsible court, my lord. And he filed the writ appeal also. The writ appeal also was dismissed. Now he is filed the application on similar ground. So on the ground that some of them, some 54 employees were dismissed by misconduct measure in 2000. Some employees might not challenge the dismissal, and they got a favorable order in the repetition. That is passed in 2016.
When was his?
He is also a part of the 54 employees, my lord. He was dismissed in 2000. So he is not challenged his dismissal. Since, my lord, some employees filed repetition, they got a favorable order. He filed the repetition in 2016. This honorable court, my lord, has dismissed the detailed order, the repetition on the detailed order, saying that 16 years are repeating and the repetition cannot be undertaken. It's challenged in the writ appeal also. Writ appeal also, my lord, I produce the orders also. So he cannot file this application now.
I disagree with him, my lord. I disagree with him. He is not wrong. Truly, 100% is not right. See, 2000.
Not right, wrong. What is his case?
He is wrong. I am telling.
Right, according to, you can submit what you want to submit, sir.
Yes.
You shouldn't say the other person is wrong.
He is actually misleading. I am telling you. In the November 2000, I was removed.
He has appeared before the party-in-person committee?
No, my lord, this will have happened much before the winding up order.
No. He is appearing as a party-in-person.
Yes, party-in-person. Party-in-person. And last occasion, my lord, this honorable court appointed one of the council, my lord, directed to be appeared.
No.
All around he was appearing.
Party-in-person has been appeared before the committee.
It is approved, my lord.
It is approved. Whatever written arguments you want to file it, we will take up this matter on next Thursday. No further adjournments. This is matter on 29th January. 30th January. No further adjournment. With the request of party-in-person.
Cell number 8. Yes, Mali Patil. For applicant. Yes.
For applicant, my lords, the application is filed by one Yogesh D. Nayak, my lords. In the last date, my lords, it was, he appears for the KSFC, my lords. In the last date, he submitted to the court that he is no more a panel to the corporation, my lords. Hence, it is our name is shown, my lords. He has not served the copy also, my lords. We don't have any instructions, neither the file, my lords.
Karnataka State Financial Corporation.
Please, my lords. We are in the panel, my lords, but in the last date, it was directed us to take the notice, my lords. Later on, he has not served us any copy, my lords.
No, Karnataka State Financial Corporation is the application.
Please, my lords.
We are referring to that.
Please, my lords. But the application is filed by one Yogesh D. Nayak. He was the panel by then, my lords, when the application was filed. Later on, he is not in the panel, is what he mentioned before the court.
Your company, your financial corporation should give you instruction.
Please, my lords. Today only we got to know that this petition was listed in the songs.
You offer this one. What is this application about?
The application is filed by KSFC, requesting the official liquidator to sell the property which is belongs to the company in liquidation. And I am responsible to one of the security creditors. I have said I have no objection. Now, the difficulty which was created by the official liquidator on the previous date of hearing was that he doesn't have any documents of title with regard to the assets of the company in liquidation. In fact, on the previous date of hearing, I have been instructed to get the copies of the documents from KID, and we have approached the KID. We will be getting it in a week. I will also share the copies to the official liquidator and I place it on the
Applicant, business master on.
and just 2 weeks, 10 months to be done.
Business matter on.
Cell number 9.
This is not for the official liquidator.
I think for the respondents, one and two here. Not that. I haven't seen my client for the last 5 years and I have no instructions from them. So I'd like to withdraw from this matter. I have no instructions and they don't come. They're supposed to carry out certain, obligations. They say they don't do it. And I'm helpless. So as a matter of fact, I see him after 5 years, I don't even recognize him. So I told him, message, he said,
Oh, yes, come finally.
one of them, he's here.
Hmm.
And told that he has engaged somebody else.
And in fact, my lord, I was not aware Leonard Senior is appearing in this case. I filed an application for recall of the warrant. There was a warrant
File an application.
for recall of the warrant on the last occasion. So there was a warrant issued against the warrant, bailable warrant, and that has been executed. So in view of that, they are present before the court. One of the accused number 2 is present. So now I came to know that Senior was appearing in the. Matter of fact, 5 years have not seen them.
Lord, winding up order has been passed on 16/4/2012, Your Lordship. 16/4/2012, Your Lordship. Even till today, they did not file the statement of affairs, my lord.
Yes.
And
why not?
looking to that, my lord, this honorable court has been issued bailable warrant against them, my lord. Now only they come up, now only, my lord, there are 3 respondents. Of the issuance of the bailable warrant.
One and he and another man called Virendra.
Now you appear for both of them.
Yes.
Whatever is the other person, even against the R1 also.
Yes,
very
Please,
good warrants.
yes, please, ma'am.
That has also been executed.
It was executed. Even despite they did not, my lord.
He is not present.
So what to be done?
Not, no, NBW has to be issued, Your Lordship.
Tell me.
But one more opportunity, what the discussion I had with them is that they may need another 2 months' time so that they can comply with the request of the upsheet curator. If they fail to do that, my lord, and finally,
Please, Your Lordship. Proceedings was initiated on, Lord, the petition was filed on 3/6/2010, my lord.
Still the time is not sufficient.
as a last, because since now I am on record, my lord, I discussed only about 5, 6
3 to 5.
Repeatedly, the official liquidator has issued the notice to calling upon them to rectify the defects. They deliberately avoid, they did not receive the notices which are issued. Even despite of a bailable warrant only, he's come up. Please, no.
3 respond.
Please, Your Lordship.
So 1 and 2, no, 2 and 3 or 1 and 2?
1 and 1 and
1 and 2 are, no, the advocate is representing and 2 is present.
2 is.
Then what about 3? What about 2?
Lord,
Notices for third?
Lord, bail warrant has been executed, Your Lordship, as per the cause list, Your Lordship. It reflects. Subserial number 3, my lord.
On October 11, 2024. The court has passed an order, issuing valuable warrant. Publishing a bond of 6,000, returnable by 9/1/2025. Today,
I appear for actually on record for R1 and R2.
No, what's your name?
Arun Pan-
Mr. M. Arun Panipar, he has not seen the client from several years. And he wants to, and he'll give up the, he's going to give the order. And then, what is your name? So and so, right, then, so and so submits the instructions to appear on behalf of respondent number 1 and 2. And we'll come up with, we'll file the wakala. It is submitted that finally an opportunity is given. And they'll rectify the defects raised in the statement. But finally, there is this matter on 20th.
Lord, in the meantime, I request Your Lordship. In the meantime, I request Your Lordship. Let them furnish the present address with all contact numbers and email ID or with an affidavit before this to the official liquidator.
Respondents, will file an affidavit along with their present address.
And non-bailable warrant has to be issued against the respondent number 3, Your Lordship, in the subserial number 2. Because bailable warrant was executed, even despite he did not present before this honorable court.
Let's see, speak with.
It is against respondent number 3, my lord. Please, please.
Now next week.
Lord, my name may be.
I can use the name of Mr. Arun Sabha. Find a wakalat.
9.1. There are all three connected.
What about the corrected matter, same order?
Same order.
Same 9.1.
Different provision.
Cell number 10.
My lord, 10, my lord.
By the memo, quoting the death of R3 that has been taken on record. My name is.
You are reporting that of?
R3. I've already reported by a memo dated 14/11/2024. That's also been taken on record. This is a criminal matter that cannot survive against legal ass. So my name will be deleted from the records by the
No.
company.
If there is a, my lord, death certificate produced by.
454 matter.
No,
454 matter.
no, death certificate is produced before this honorable court, my lord. What,
No, that's the, no, he is no more. It's a
my lord,
criminal action.
my lord, if death certificate is produced along with the memo, my lord, R3 death, my lord, this application will not survive as far as R3 is concerned. I have not.
I filed 11.
Let's.
Along with the death certificate.
Yes.
The council of Perry, representing, then council of five, R3, subjects, R3 is, no more. Right on page 7, 2023, along with the memo, he has also filed the death certificate. It is submitted that the present application is
Fourteen 11.
54, 5. And, Friday of the companies act. As R3 is no more. So, nothing survives the consideration in this petition.
As far as R3 is concerned.
R3 is concerned, survives the consideration. As far as R3 is concerned. So, considering the memo that it's filed, the council applying the official liquidator also submits that as already the death certificate is filed, that R3 is no more. Nothing survives against R3.
Yes.
After this application is concerned, accordingly, the application is dismissed. After that, R3 is concerned. What about the?
My lord, R1 and 2, my lord, I have not intimated defects, my lord. I have sent a letter also to them. My lord, I have filed a memo, my lord. In that memo, 12/12. My lord, my memo is dated 12th December, my lord.
It was on 22/11/2024. Whether it is served on them.
But there is no intimation that the acknowledgement is required. Wait for acknowledgement.
Then council submits that, after the applicant submits that. For the old submits that. That if they've addressed a letter on 22/11/2025 to rectify the defects in the statement of offense. And so far, they have not received any reply to that.
But
Acknowledgement is filed before the court, so that it is served on him.
my lord, R1 R1 is being represented by a learned counsel, my lord, CP Praveen. Praveen. And R2 is also being represented by one Vijay Kumar Prakash. Yeah, I will wait.
This we have to know.
Yeah, I will.
Memo should be filed to the effect that the fee is served on the receiver. No representation for the respondents. This is matter on, 4th of March. Yes.
Serial number 11. Yes, Mahadevan.
But this is under section 454. Lord, A1 was died and A2 is reported as served. So we have to take the steps against the A3, my lord. We have requested he who is in Pune, my lord. We have requested the commissioner at Pune, my lord. Lord, A1 was died, lordship, and LRs cannot be taken, which is under section. Lord, please, lordship. Please, lord. Lord, A2 was served. A2 was served unrepresented.
Things are taken as 5 of the company back. These are raised to the as well as what is that? R1 is R1.
Yeah, please, lordship.
R1.
Yes.
Accordingly, then what about
So far as the R3 is concerned, who is residing, R3, my lord, R3, my lord. R2 is served, your lordship. So far as the steps against R3 is concerned, my lord, he is in Maharashtra. We have requested the police commissioner at Maharashtra to find out the correct address. And the steps taken by the official liquidator is ready to file the report. It may be have it after 2 weeks, my lord. In the meantime, we will secure the. Please.
Serial number 12.
Told, my lord, the steps against the LRs of deceased R1 is taken, my lord. PF was paid on 10/12/2023, 2024. Notice has to be already, lordship. Told. Notice to LRs of the deceased R1, my lord. CA 105 of 2023, my lord.
Respondent 1 died. It is the was the PA number. Promote for 23 is back to bring the legal representative of respondent number 1. You can notice to the to the respondent to the support the respondent.
Serial number 13. Raghuram Chandra.
subject matter of this application, my lord, was also subject matter of attachment for the PMLA appellate tribunal. So this honorable court had felt that let those proceedings be disposed of and thereafter this can be taken up. My lord, I am told that the judgment is out. It had been reserved 2 months ago. I just placed that on record. Would your lordships please have it after a week, my lord? Or after 2 weeks, I place it on record.
Please.
Differently that the property is under this application is also a subject matter of the appeal pending for the
PMLA appellate tribunal.
PMLA appellate tribunal. Then the matter is also the council of the same for the court, so that the dispute can be resolved. This matter on 10th of March.
Just matter of disputation is pending before the Honorable Supreme Court. As is likely to post in second week of February. Maybe call out.
Cell number 15. Cell number 15. Yes.
Official page, OAC number 2022. Three models of the first, let me be listed at next week, my lord.
What is that?
We have challenged the interim order of this court, my lord, in OAC, and OAC is honorable division bench was pleased to grant interim orders. That will we come to.
It is already granted.
Please.
He submitted the interim order discretion of the order is granted.
OAC number.
What is the number?
14 of 2022.
This is matter on.
Cell number 16.
For the respondent, my lord, if you cut nine. And the application filed for recovery of some data during filing this was before the registrar for the evidence, my lords. While this was pending for evidence, my lords, the OL had actually given me a communication that they'll disconnect my utility services. And thereafter, I had filed CA 388, my lords. I have an interim order in CA 388. I had also deposited about 2 crores on the last date, my lords. I'm led by senior counsel in this matter. He has an inconvenience today. He's on his feet in another court. May I request next week, my lords?
Finally, my lord.
In
Please, madam.
239 respondent, my lords, in CA 388, I am the applicant.
Application CA 139.
No, in that CA 388, I'm the applicant. In the main CA 239, I am the respondent, my lords.
This is matter on 30th finally.
My lord.
My lords,
CA
interim order.
139 CA, my lord. The
CA 239.
I know, my lord. CA 139 of 2021. It's a copy filed by them. They've not served it on me and requesting service of 139 of 2021.
I will just serve them.
The applicant, after the applicant CA number 139 of 2021. So the copy.
I'll verify it.
Official liquidator.
My lord, if your lord indulges me in CA 362 of 2024. That is a short 2, my lord. There's a short CA for me. The matter is already pending in evidence, my lord. There are 2 documents which I wanted to mark, originals of which were not available. These were to mark certified copies of those, my lord. For the matter to continue in evidence, it can be allowed, my lord. Please.
My lords, my interim order may be extended, my lord. Number 17. Liquidator.
Through paper publication, my lord. Open it. My lord, para 3 onwards, my lord. Respondent not traceable even though efforts have been taken by official liquidator. for ascertaining the correct address and respondent by addressing a letter to extract of the company and local inquiry conducted through staff of official liquidator at Hyderabad. Official liquidator has not been able to ascertain the correct address of respondent, may be therefore exercise power similar. Requesting for paper publication, my lord.
It is that.
My lord, that's dated is 11/9. 268. Number 2, CA 268.
Also, in order to do the newspaper, I'm preparing and the education establishment account is in the mentioning the date of hearing.
Or dates may be mentioned.
Date of hearing as on or before.
6/2.
Date of hearing as
22.
Take the dates.
Cell number 18. Chaitanya Chinnappa.
My lord, for the respondent number 2 in the matter, my lord. I appear for the applicant in this matter. Lord, applicant is a creditor, a financial creditor.
Okay.
And Lord, the company went into liquidation. Thereafter, my lord, certain assets of the company had to be sold by the official liquidator. And it had to be sold because, my lord, we had a security interest with respect to that property. It had to be sold in consultation with us. Accordingly, my lord, a auction was conducted of the property with various terms for the auction. And one of the conditions was that if there is a liability towards taxes over a certain amount of money, which is about 20 lakhs, we agreed that we will bear the same as a financial creditor. These are the facts as they are. And my lord, that was a requirement official liquidator imposed on us. And we said, all right, we'll give an undertaking that we will do so. Thereafter, my lord, BBMP apparently raised a claim for some 1 crore 26 lakhs, saying there is a tax due to the earlier period. Then, my lord, that demand was sent to us saying you must now pay that demand. To which, my lord, our answer really is, while of course we have given an undertaking, the provisions, my lord, of the Companies Act prescribe that a secured creditor stands ahead of everyone else because of section 529 and 529A. And the liability, my lord, of crown debts or even of debts of BBMP has to be adjusted from the estate of the company. And if there is anything additional, my lord, that really is not there or the company doesn't have money, then everyone loses. Financial creditors, crown debts, taxes, everything is lost. Therefore, you cannot impose on me the requirement that you must now pay the liability of BBMP. That's, my lord, the central issue in this case. And that's the only question, my lord, which really arises because that's the demand on us. Neither can that be fastened on the subsequent purchaser. Because subsequent purchaser has purchased it, of course, my lord, without having any liability in respect of taxes. For the period of the winding up, who should bear this taxes? One question, my lord, which arises. And therefore, my lord, that is a submission I want to make. According to me, my lord, it is covered by one judgment of the Supreme Court. My lord, I'll give you lordship the date. The date, my lord, of the winding up was 4/12/2012. 12. Then, my lord, on 7th, if your lordship takes a list of dates, it's there on the petition itself. The sale notice, my lord, was 28/2018. if my lord sees page 2 of my application. And on 8/2/2019, the sale was confirmed in favor of respondent number 2, who has appeared, my learned friend appears for respondent number 2. Then the sale proceeds were transferred to us and the entire amount was paid. 16/3/2020, which is the important date, we were made to undertake to pay the property tax and electricity dues pertaining to scheduled property in a situation when the same exceeded rupees 20 lakhs, which is retained by the official liquidator. We issued the demand draft. Then, my lord, if my lord kindly comes to item number 11 on the next page, 8/4/2021, they asked us to make payment of this 1.26 crores, the official liquidator. Therefore, my lord, today we are really on a question of law as to whether in a winding up process where the overriding preferential right as well as the preferential right is contained in these two provisions, can there be an imposition at all, even if there's an
16/3/2021, 2020 undertaking.
my lord, our undertaking? We undertook, my lord, that if there's any additional tax that has to be paid, we will bear it. But the point, my lord, is whether we bear it or not is one issue. Whether they can impose upon me contrary to law is the second. But third, whether there can be a liability at all towards this tax for that period. The winding up period. The notice, of course, not if it is after the sale, he bears the liability. There's no question then. It is only for the period up to the date of the sale. And during the winding up period, because as your lordships know, a company continues to exist post winding up until it is dissolved. Winding up is the process of dissolution of the company. That, my lord, if your lordship sees my undertaking, can I humbly request my lord to kindly come? Yes. Which one? Sale, yes. My undertaking is on 16/3/2020. Please see page 43, my lord. I, so and so, Chief Operating Officer, so and so, hereby undertake on behalf of trustee of the trust, I'm sorry, my lord, to pay the excess amount, if any, towards the property tax and electricity dues so calculated by concerned authority, in the event the property tax and electricity dues exceeding 20 lakhs with respect to the property number so and so, Pina, Bangalore. In so far as an undertaking, I don't think, my lord, there's another letter also they've produced. There cannot be a dispute with respect to the undertaking that I have given. But question, Lord, really in my humble submission is whether the demand can be made over and above what the entitlement is during the period of winding up. And that is, my lord, statutorily controlled by virtue of section 529. Can I, my lord, straight away take your lordships through section 529 and 529A, my lord? I've actually put them all together in a citation report. May I pass on, Lord, a set of citations as well as the provisions also there in this itself. I've put it together so it's easier. Passed on. Copy for I have a copy. Mark. Some portion is marked, but you don't mind, no? Can I request, my lord, to kindly come to page 26, no? I'm sorry, to page 22, my lord. This is 529A. Overriding preferential payment. Notwithstanding anything contained in any other provision of this Act or any other law for the time being in force, in the winding up of a company, A, workman's dues, and B, debts due to secured creditors to the extent such debts rank under clause C of the proviso to subsection 1 of section 529, pari passu with such dues, shall be paid in priority to all other debts. Debts payable under clause A and clause B of subsection 1 shall be paid in full unless the assets are insufficient to meet them, in which case they shall abate in equal proportions. Then, Lord, may kindly come on to the next page at page 23, which is section 530. This is the preferential payment. Well, I'll quickly take your lordships to this. In a winding up and subject to the provisions of 529A, there shall be paid in priority to all other debts, A, all revenues, taxes, cesses, and rates due from the company to central or state government or to a local authority at the relevant date as defined in clause C of subsection 8 and having become due and payable within the 12 months next before that date. So there is also a limitation of how much is contained and covered. And then wages, salary of others, my lord. I won't trouble your lordships with all of those.
12 months next before the date of.
Winding up.
Winding up.
Winding up order. So that 12 months is covered, which is why my lord, law also limits to what extent a claim can be made in a case of a winding up. Of course, my lord, if it's a regular case where there's no winding up, then whoever purchases will then possibly become liable to pay the property tax if the property tax is not paid, and then he can pay and collect. But in the case of winding up, there's a limitation as to how much is chargeable and how much really can be claimed. That's the first point, Lord, insofar as that is concerned. Now, please come, Lord, to clause 535, the foregoing debts, on the next page. The foregoing debts, all the debts, Lord, which are there in that waterfall mechanism, the foregoing debts shall rank equally amongst themselves and be paid in full unless the assets are insufficient to meet them, in which case they shall abate in equal proportions. And so far as the assets of the company available for payment of general creditors are insufficient to meet them, have priority over the claims of holders of debentures under any floating charge. That may not have relevance, my lord. Therefore, these are the two provisions, my lord, which in my respectful submission covers the extent of liability that BBMP can make and or I can be held liable to pay. It could be, my lord, that even at the very worst, if that 1 year, that 12 months is not covered under the 20 lakhs and there is something over and above that, then maybe there could be a claim saying you must pay that because you've undertaken to pay. But that cannot be a claim beyond that period, even if BBMP makes a demand, either against the person who's purchased the property because he's purchased it in the course of binding up, and against me, my lord, because I have an overriding preferential right to the entire payment as a secured creditor. Now, this, my lord, was considered, if your lordships take the first judgment in Champdani Industries versus official liquidator. Can I request, my lord, to kindly look at para 8 first, at running page 4. Company went into liquidation. It was directed to be wound up. OL indisputably took charge of both movable and immovable assets. Fact that the company went into liquidation was given publicity. Respondent municipality did not file his claim for the official liquidator. It did not stand in queue to get the same recovered and or adjusted from the sale proceeds. I understand, not in this case also, they have no claim from BBMP.
One of them has a
Bescom had a claim, but no, Bescom has no dues. No, in the process of examination of the claims, is there a claim from BBMP? That, of course, the official liquidator will have to answer. Then, Lord, may kindly come at para 15, page 6. The respondent municipality was an unsecured creditor. In that capacity, it cannot stand on a higher footing than an ordinary unsecured creditor who is required to stand in queue with all others similarly situated for the purpose of realization of the dues from the sale proceeds. Then para 24. The municipal corporation indisputably is not a preferential creditor. Companies Act in relation to winding up of proceedings is otherwise a special law, while distributing the assets between the creditors and unsecured creditors. The provisions of 529 and 530 must be complied with. And para 29, ultimately, my lord, Supreme Court says, dues of the municipality would also not even otherwise come within the purview of the crown debt. Even a crown debt could be discharged only after the secured creditors stand discharged. Therefore, their position is no better. That, of course, my lord, has been followed in a large number of judgments. I don't want to trouble your lordships with all of those.
No, apart from this, there are other things.
I don't know if there are any other assets, my lord, because this, please, this was secured to us. I don't know if there are any other assets. Only asset. This asset. This asset is sold. Now the company possibly will go into dissolution once they have determined all the claims. If there's any money left after paying the secured creditors, then Lord will be, and the workmen, of course. The pari passu right of the workmen is already exercised. I understand, Lord, the workmen also have been paid their liabilities. Therefore, all that is left now is, if something is left, that has to be distributed in terms of the waterfall mechanism under section 530 in equal proportions, or it will abate in equal proportions. So everyone's liability comes to an end. Well, they are all similar. They all follow the same principle. And of course, under Securitization Act, the liability again, Lord, is preferential to everyone else, because the law specifically provides, if that I can possibly show, my lord, the provision of the Securitization Act, which was considered in the second judgment by the Bombay High Court. I would request my lord to kindly come straight away, my lord, to para 28, page 14. The moot issue arising here, whether the secured debt assigned in favor of petitioner has a priority over government dues or tax dues, is no longer res integra. Then it is considered, various judgments are cited. And my lord, after considering all of them, I won't trouble your lordship with all those. Page 16 and para 31. In our view, this is after considering 31B of the Securitization Act. On top, my lord, lordship is the Securitization Act. Notwithstanding anything contained in any other law for the time being in force, the rights of secured creditors to realize secured debts due and payable to them by sale of assets over which security interest is created shall have priority and shall be paid in priority over all other debts and government dues, including revenues, taxes, cesses, and rates due to central government, state government, or local authority. Therefore, that's an added provision which aids us in saying we stand ahead of everybody else. And finally, 31, in our view, the aforesaid views cover the case of the petitioner herein. There is no reason for us to take any other view in this case other than to say that the charge of secured creditor would have priority over government dues under Income Tax Act. There is no provision in Income Tax Act which provides for any paramountcy of the dues of Income Tax Department over a secured debt. And then Karnataka High Court also, my lord, has taken a similar view, a division bench at page 18 and my lord at para 10. Yes, ma'am, that has lays down the same principle of law. So far as OL is concerned, I'm not saying OL, of course, is liable, but OL has, if there's money, then it has to be paid in the order of preference. If at all, my lord, BBMP has to say something.
The auction purchaser, my lord, is the contesting respondent. I will add to his submissions if there are any after the.
Yes.
Insofar as BBMP is concerned, I represent the BBMP. Short question, my lord, is whether second respondent or the petitioner who is liable to pay the taxes. Now, as on the date when the demand was raised, Lord, it was second respondent who was in possession of the substitute property or the petition purchaser property. Lord, but however, the demand pertains to, Lord, the year when it was in the custody of the company which is under liquidation. Insofar as I am concerned, my lord, from wherever the money comes, it is fine for me. Only thing is, money has to come into my account. Now, both of them are relegating their responsibilities now. Now, this is a problem. That is where, my lord, this court, my lord, on the last date of hearing, permitted me, my lord, to proceed against the property. And an order to that effect is also passed. So that is where, my lord, now we'll have to see who will pay my money. If they don't do it, my lord, I will proceed further in accordance with law. What is property? My lord, property is a removable property, my lord,
yes,
which belongs to
industrial land.
Industrial land.
Physical property, my lord.
It is sold to respondent number 2.
OL and the petition.
Purchase now will pay everything right from 2012.
That's exactly
what can't be done.
That is what applicant is saying. It is his liability to pay.
No, I'm saying no one has to pay it because it is only for 12 months, as your lordship saw in 530, 12 months after that date. That's only liability because winding up can maybe take 10 years, 20 years. If it is in Bombay, for instance, it may take 25 years by the time anything is done. Therefore, law itself prescribes that there is only one extent. No, he can't. No one has to pay.
May I make
it is part of really liquidation estate.
In addition to 529 and 530, my lord, there are two other provisions which are relevant. The position of the official liquidator and the background behind which the sale was brought, the sale notice was published and auction was carried was that the property, my lord, is the taxes owed on the property are costs of liquidation, my lord. If I may invite your attention to section 476. 76. Power to order costs, my lord. the court may, in the event of assets being insufficient to satisfy the liabilities, make an order for the payment out of the assets of the cost, charges, and expenses incurred in the winding up in such order of priority, inter se, as the court thinks just and fit. My lord, this is an additional provision which is giving the leeway to this court to manage the assets of the company before they are sold. Yes, there is a waterfall prescribed under section 529 and 529A. And as learned senior counsel pointed out, yes, there is a waterfall in which the workmen and secured creditors are provided the highest of the ranking there. And any debts, including that of BBMP, will rank lower to the debts of the secured creditors and workmen. This provision, my lord, it gives the flexibility to this honorable court to alter that waterfall in and make an additional claim on top of it under 476. Say, for example, if I have to sell that laptop, for example, my lord, if it is not working, no one will take it, my lord. If I incur a cost in repairing that laptop and fix it, the cost that I incur in repairing the laptop is 476 cost, my lord. Otherwise, that asset value will become zero. I have to spend, say, 100,000, whatever it is, on the laptop to make it workable for
the 12 months.
Please, my lord.
There should be a determination.
Conclude. May I just conclude this line, my lord? I'll come to that eventually, my lord. If I may, after 476, my lord, if I may invite your attention to rule 338, my lord. Please.
7 crores, 25 lakhs. 7 crores, 25 lakhs.
5 lakhs, 31,036.
Yes.
To the,
To me, ma'am.
Correct, my lord.
Secure
That
what is the amount out of the sale proceeds?
that plus 20 lakhs, my lord.
6 lakhs.
No, 12 plus, and that's almost 20 crores. No, 20 crores was the total sale, please. And that did not even satisfy our liability.
That is the submission I'm trying to make, my lord. The taxes, there are three tax. Please, I'll come to that, my lord. Just give me one indulgence for 1 minute. At the time, my lord, the distribution of dividend has happened on the application of the secured creditor before all the creditors' dues are crystallized and amounts are dispersed. In the interim, because they being the charge holder of the property, requested for interim dividend, my lord. Interim dividend was granted. If I may invite your attention to orders at annexure A, B, and C, my lord, which I have produced along with my statement of objections, that shows the chronology in which that amount was dispersed, my lord. At the time of, may I just complete, my lord? I'll just point out the relevant paragraphs once, my lord. In these orders, my lord, because of the asking of interim dividend, my lord, this court was of the opinion that interim dividends may be given subject to quantification of assessed liabilities at that point. At this point, my lord, because neither BBNP has given us the details of tax outstanding at that point, neither BESCO.
Point was never the BBMP has approached the official liquidator.
Prior to the sale.
Prior to the sale.
Yes, my lord.
You should make claims.
Please, my lord. Please, my lord. The other respondents are now saying they have no dues, so I'm not addressing them. As of now, only BBMP is the one who is addressing claims. Please, my lord. The two, because with respect to property, when we sell a property, we always know that there is tax liability there. Without having details to quantify, we had taken a sum of 20 lakhs as a rough figure to offset any liability in the interim dividend that was granted to them. They had to, for example, my lord, if the dividend is of 100 rupees, we had kept 10 rupees just in case any liabilities arise so that we can pay. For that 10 rupees, my lord, the applicant had provided these two undertakings, my lord. If I may invite your attention to page. There are two undertakings, my lord, which basically say that if it exceeds 10 rupees, whatever I have kept as an approximation, that will be recuperated by them from the proceeds that we have given them without crystallizing debts of all the other creditors who are standing in line. This is now being sought to be challenged, the undertaking given to this court itself, that this amounts will be paid if it falls in excess of these amounts. Can I come?
Go to the official liquidator.
Please, under the orders of the court, I will read that as well. And my lord, if I may invite your attention to a couple of clauses of the sale notice that was published, which is a joint sale, my lord. If I may invite your attention to annexure A, let me go annexure wise, my lord. Please, my lord. Please, my lord.
No page number. Mine also doesn't have any page.
Mine
number.
also doesn't.
If your lordship said. Mine also doesn't have page numbers.
We don't have page
Or
number
annexures.
13 onwards, my lord.
No, I don't have annexures also.
Annexures also is not.
Doesn't matter, no, let my learned friend argue. We'll.
Separate. We
I don't think
apologize
his also is
profusely. I mean, it's not numbered for me as well, my lord. If I may invite your, the CA 9 of 2010.
You now might as well. We used to.
My previous one number to can,
Please, my lord.
give the number.
Please, my lord. I am referring to the company petition number 9, company application number 188, my lord, which is the first annexure.
Little bit.
Please, my lord. This one, first annexure to the.
299.
In 299, my
In
lord, I think.
299, the annexure is to 188, my lord. The order, it is an order, my lord. Annexure 1 is a previous order of this court.
Page 13, page 13.
Page 13, my lord.
No, it's the same application, lord. In the objection statement, there is another order in a company application number 188.
Please, my
They
lord.
have produced.
Your lordship is looking at the OL's objections to CA 299, my lord, in that annexure 1, annexure A.
Objections to this.
Please, my lord. Please, my lord. This is the app.
Page number?
The applicant, as your lordship sees, is the applicant in that application as well, my lord. Please, my lord, if I may invite your attention to page over, my lord, internal page 2, ink page 14. This application has been filed by JM Financial Asset Reconstruction Company for seeking directions from this court to direct the official liquidator to release the property in favor of the applicant company, which is the mortgage in question, my lord. In paragraphs 10 to 12, my lord, joint valuation and sale is permitted, my lord. If I may invite your attention to the next annexure, my lord. Apologies, my lord. Annexure D, my lord.
That's page number 21.
Please, my lord. My lord, that is a short sale notice, my lord, saying that the entire sale notice is on the website, my lord. That is in page number 38, my lord. Annexure E, my lord. Terms and conditions of sale, my lord. 38, sir. Yes. Para 18, yes. Sir. Para 17 and 18, I am reading, your lordship. Please, my lord.
Terms and conditions.
Terms and conditions, para 17 and 18. Because the joint sale was allowed by this court as per previous orders, my lord. These are the sale terms jointly drawn up by OL and the applicant, my lord. Para 17, my lord, the sale certificate shall be issued by the assignee of the secured creditor, that is the applicant in CA 188, which is applicant before your lordship, namely JM Financial Assets Reconstruction. With respect to the land put to sale, stamp duty so and so shall be borne by the purchaser, my lord. 17, my lord, 18 also.
Conditions of sale.
Please, my lord. In that, I am reading paragraph number 17 and 18, ma'am.
17, that's what I'm saying. 17 starts with the land. Subject matter of sale is personal property.
No, terms and conditions of sale.
Yes, sir. 18 and 19, my lord.
Starts at page 40.
For number 18 and 19.
38, my lord.
He's reading 19.
I am reading,
Purchasers shall not be liable to pay.
please, my lord.
That is 19 in this page.
Please, my lord.
Yes, yes.
The purchaser shall not be liable to.
My conditions shows 18. Maybe it's a different document then, because
My lord,
it can't be 19.
My lord,
This-
17 is, if
No,
I
no,
may.
put it in,
But these terms and conditions
Yes,
have been
your
issued
lordship,
for CS 340 of 17.
Is the sale notice,
Please, my lord.
correct?
Please, my lord.
It appears in
With-
page 38 and 39.
Please, my lord.
Thereafter, at page 40,
Please-
terms and conditions. of
Please,
sale.
my lord. In that, I am read.
What I get at 17 is the land, comma, the subject matter of sale is personal property of the ex-director.
That's not here.
19 is the purchaser shall not be liable to pay.
That's different. It is different.
Yes, my lord.
I think it
There
is
is
something it is correlating with what newspapers are.
My lord,
Not correlating with mine.
I am supposed to have filed this document. My lord, it is.
Your lordship,
document.
can we just see it? Not because
We both seem to have the same one.
we have the same document.
My lord, as per the terms and conditions which we have received,
Auction purchaser. No, this is different. This is not the one.
one of the term,
The secured creditor are having the same paper.
We have same papers, quote, and the auction purchaser has the same
The
papers.
people. May I seek some time to verify what the submit?
Maybe number is changed.
Please, my lord.
The papers have and this also have.
The condition that I am relying on,
Hmm?
which was jointly finalized, is that the auction purchaser need not bear the taxes liabilities. Please, my lord.
How can it be? It's not here. In
So
my
as a
copy, it's not here.
cumulative factual narration of three things. Please, my lord, it is.
And to see any benefits with respect to property accruing on or before the date of.
Handing over possession.
That.
That- Please, my lord. Correct, my lord. The liability which BBMP is saying is a liability prior to this.
Oh, yes.
Yes,
Between 12 and 16.
please, my lord. The cumulative narration of three facts, which I'm drawing a conclusion. One is that, my lord, at the time of payment of dividend, it was not a finalized dividend. It is an interim dividend where I have kept certain monies to pay costs if they arise, my lord, with an undertaking that if costs exceed that, I will be reimbursed. Those are the 200. Please, my lord. 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 Please, my lord.
No.
I gave him minus 20 lakhs.
Minus 20 lakhs and minus workman's pari passu dues, everything else was paid to us.
Paid to them.
Everything is paid to us. That is not, and that does not satisfy my claim.
The only argument that I want to make is that the amount that was deducted and the amount under undertaking which was required to be recouped is a please, my lord, for the purposes of, please, my lord. Please, my lord. It is for exactly this property and this value to be taken by them, my lord. If I may just continue.
Yes, just.
Yes.
It's fine, but, in the binding of proceedings, it's supposed to take care of all of the.
From the assets of the company.
That's it. Now, you have given an undertaking.
An undertaking.
Saying that even if it is, even if there are two undertakings.
Yes, Lord. Same thing, Lord. Undertaking is anything about 20 lakhs will pay. The point, Lord, is not that. 529 and 530. Yes, my Lord, should read all of that. But the law, my Lord, as laid down by the Supreme Court now is, there cannot be a claim of BBMP beyond this amount. The whole issue, my Lord, is really as to what BBMP can claim. What BBMP can claim is contained in 530.
It's 12 months.
12 months from the date of winding up, which is why, my Lord.
Simple example, my lord, because it is land, it is taxes, and I have to make it worthy of sale, my lord. If
No, this is fair.
If I make.
First of all, BBMP, when once company is going to go in the binding of proceedings.
Please.
They are not participating.
Please, my lord.
They have not even made a claim.
They are not participating.
At the relevant time, they have not made, they have made it post that, my lord, with a delay. Please, please, please.
We were not aware about what the taxes.
But we were aware that there could be taxes. That is why the terms of sale has that provision for it to be recuperated. Please, my lord.
Your submission.
My lord, the 18 crore or the amount.
Then you will be able to submit.
Please, my lord, apologies.
So, What do you say that, what is the purport of that provision? That 430?
530.
539 or 29? What is the purpose of that? Any of the arrangements cannot be contrary to the provision.
I appreciate, my lord. That is why I'm saying the response to that is 476 read with rule 338, my lord.
The provision. That's what I'm asking you.
Please,
My
my lord, if I
lord,
may invite your attention to the rule, my lord, it further clarifies that
Just take
position.
one minute. I'm sorry, my learned friend may consider this. 529A is notwithstanding any other provision in the Act. 529A is notwithstanding anything contained in any other provision of this Act or any other law for the time being in force. It's above everything. Therefore, you can't say 476 overrides 529A.
It's about the preferential payment.
Yes, my lord, which is why it's an overriding preferential payment. Because 530, no, I'm saying first is overriding preferential payment. That is us and workmen. We override everyone else. Then comes preferential payment. But 529A, to answer my learned friend's argument that 476 I can use, answer is in the first sentence itself, notwithstanding anything contained in any other law for the time being in force or any other provision of this Act. This overrides everything. Therefore, my learned friend can't say you must read 476 and then control 529A when it's an overriding provision. Therefore, that entire thing has to be read in the context of 529A, which is why otherwise Supreme Court. Which one?
Then there is no.
Yes, my lord.
there is no dispute on that.
Correct. I'm not even arguing that, my lord. 476, my lord.
476.
My lord, because in a
order costs.
liquidation process, in a winding
Not
up
costs.
process, there have to be certain costs that has to be deferred by the official liquidator, my lord. It can, please, my lord, I'll read it with the rule as well, my lord. 476 power to order cost. The court may, in the event of the assets being insufficient to satisfy the liabilities, make an order for the payment out of the assets of the costs, charges, and expenses incurred in the winding up in such order of priority inter se as the court thinks. May I read the rule, my lord? It has 6 set of courts which courts can order, my lord. Rule 338, my lord. Please.
Which rules?
From 1915. Costs and expenses payable out of the assets in a winding up by the court, my lord. This the corresponding rule to that provision is this, my lord. The assets of a company in winding up by a court remaining after payment of fees and expenses properly incurred in preserving, realizing, or getting in the assets, including where the company has previously commenced to be wound up voluntarily, such remuneration, costs, and expenses as the court may allow to the liquidator in such voluntary winding up shall, subject to any order of the court and rights of secured creditors, if any, be liable to the following payments which shall be made in the following priority, namely, firstly, secondly, firstly, my lord, the tax costs of petition, including the tax costs of any person appearing in the petition on whose costs are allowed by the court, the costs and expenses of any person who makes or concurs in making the company statement of affairs, the necessary disbursement of the official liquidator other than expenses properly incurred in preserving, realizing, or getting the properties of the company. I'm relying on this, my lord.
Other than expenses properly incurred in preserving, realizing, or getting in the properties of the company.
Please, my lord, if I read it with the first line, my lord, subsection 1, sub rule 1 that I read, my lord, whatever cost that if I say, for example, my lord, in addition to things like taxes, my lord, generally what we do is also employ security guards to man the property till the time it is sold. Now, the security guards cannot be standing after the secured creditors to get that money. I'm saying that the amount which I have quantified and kept as cost, including the payment of taxes, is necessary for me to be able to sell the property in the first place. That is why if I'm employing a security guard, he will be paid, even though 529A gives preferential, overriding preferential payment to secured creditors. There are some costs that I incur to of
costs, the property tax and all. That is not within the.
Property tax 530.
Which one?
Their property tax and all.
The understanding and the terms of sale were drafted on that premise. Please.
taking care of it.
Please, my lord, please,
That was taken care of. So the purchaser is not liable.
please, my lord. That's it.
The BBMP and the secured creditor.
Please, my lord. There,
He has a preferential.
please, my lord.
One line of judgment that it is for the parties, even if it is like they can't be above the official creditor, even the municipality or others.
Please.
Whenever these proceedings are going on, winding up proceedings, it is for them to come before the official.
Make a claim.
The only thing now that the court is there, in the proceedings, voluntarily you come forward and said something.
Yes, ma'am.
So what is?
No, no,
you
the-
say that undertaking has no significance.
Correct. I'll tell you, Lord, why I'm saying this. The undertaking, my lord, cannot be beyond the law. Therefore, what is the right of BBMP and to what extent is the question? And that right is fixed by section 530. To the official liquidator. Yes, my lord. But then the point, my lord, is not that. I've given an undertaking, I'm not reciting from it.
This is clear.
Yes, my lord, I've given an undertaking. There's no walking out of that.
He comes and takes an undertaking before the court.
Yes, ma'am.
Saying that I'm recording that because we don't look into the provision then.
No, I'll explain this. I understand, which is also, my lord, the first question I also had when they showed me these papers saying, how do you get over an undertaking? The answer, my lord, was, I cannot contract out of law, first. Nor, my lord, I can say with absolute confidence, will the court ask me to give an undertaking contrary to law. In no case, my lord, will the court say give an undertaking contrary to law. The question, my lord, is, if I give an undertaking,
Before this court, you give undertaking which are not even the list is not.
no, true, it may not be the list.
Of course, it is connected to them in somewhere before some other court.
Yes, my lord. I agree, my lord. Normally, my lord, an undertaking will always be upheld. There's no, I can't even dispute that argument at all. If it is between two parties. Now, in this case, my lord, there is no crystallization of liability. I'll tell you, lords, why I'm making this submission. In the course of winding up, it is necessary for all creditors to make a claim before the official liquidator. The official liquidator, my lord, will then take the claim, adjudge it, and decide how much is due to that particular party. If I'm a creditor or the state, or it's a crown debt, income tax liability, VAT, GST, all of them are required to make a claim before the official liquidator. Official liquidator will then draw up a list of all the creditors in terms of the Companies Act. And then we'll say who is overriding preferential, who is merely preferential, who are the workmen. No, it does. I'll tell you what. I'm secure. Secure creditor, I'm the only one. Everyone else is unsecured. Unsecured creditors have certain rights under the law. And that is to the extent of 12 months next before that date. So all taxes are arrested on that date, whether it is property tax or personal taxes of the company or anything else, or GST for sales, everything arrests on that day. Therefore, my lord, whatever may be the liability, suppose, my lord, the liability, let us say, is 25 lakhs for that 1 month, which they must have determined if they have, because there's no claim, they've not determined it. Then, my lord, I maybe have a liability to pay 5 lakhs because I've given that undertaking at best. But to say that you must take the entire period when the winding up was going on and pay the entire taxes for that period, BBMP can't make a claim.
It's taxes.
Can't make a claim for taxes. That claim for taxes is what.
The person who is in occupation of the property, who has sold the property, who has purchased the property, or somebody else has to pay.
No, my lord, those taxes won't.
Property taxes has to be paid.
It goes, my lord. The property taxes go. For that period, there's no claim. Nobody can make a claim for that period. In law, my lord, because of the provisions of the Companies Act and the interpretation of the law, which your lordships now, whether it is that property or any other property, it becomes, my lord, it is. My lord, no, I'm saying it is almost like all the properties come into a hotspot. And that properties have to be sold by the official liquidator to anyone else they consider appropriate.
When you voluntarily has come before.
My lord, yes, madam, but there's no tax liability. There should be a tax liability in law. Lord, that's what I'm saying. If there is a tax liability,
that is justifiable in a winding up, then alone will my undertaking apply. It should first apply in a winding up process.
Which one, my lord?
Page number
Undertaking, yes.
There are two, my lord, page 66 of objections and page 69 of objections. my lord.
There's a clear undertaking given by them.
No, there's no doubt.
Insofar as.
But there should be a
Hint of.
Lord, BBMP
No, at
should have a
that time-
right to make a claim for taxes.
One second. At that particular point of time, though there was no claim, my lord, they came before the court and made a statement before the court saying that we are going to undertake that any amount in excess of 20 lakhs, I'm going to pay.
Correct.
This is the statement made. My lord, at that point of time, if they had brought to the notice of this court that this is the provision of law, so I will not come and give an undertaking, and subject to that, let me give an undertaking. If they had said that, then my lord, making these statements now before your lordship.
Yes, my
At
lord,
that
if,
time, they did not do that.
If that qualification was made,
Was
the
there?
entire 17 crore would not have
Yes.
been given, my lord. Because it is
If
a
that
temporary
qualification were
payment
to be there.
subject to crystallization of others. In the normal course, my lord, if we were to pay them in line when as per our procedure, my lord, we would have first paid property tax, my lord. And after that, we would have declared dividend on the remaining amounts left for sale, my lord. There, essentially, the 20 crores would have reduced at
Not to
that
530.
point.
Taxes is not part of it.
In the cost, yes. It's not there.
Was that 27?
76.
476,
What?
that will not come to your rescue, or you cannot rely on that. Now the next issuer, now who has to, then that provision, then when we can't look at that 476 or whatever, then we have to look at 530.
5301A, 1A.
Is the, from when, once the winding up proceedings are initiated, till everything is concluded. So what is the liability, what is the law on that? And what is the provision say?
My lord, with assuming the position, my lord, then the submission made by learned senior counsel is correct to that extent that BBMP will not be able to recover taxes. Correct.
So it is only for the
12 months.
period, whatever it is.
No, my lord, that my submission still remains that your lordship may hold otherwise. Please, my lord.
So there's a cost according to you.
Please,
it
my lord.
falls under 38, read with the,
Please, my lord. That is the submission. Please, my lord. Please, my lord. If that is rejected, my lord, then it has to abate.
Yes, Mr. Khan.
My lord, kindly see the undertaking given before your lordships. As I said, my lord, that when this undertaking or an order to give an undertaking was passed, there was no qualification as such. Since they did not qualify or say before this court that subject to so and so provision of law, my lord, we give this undertaking. This undertaking given before this court or before the OL, my lord, is an absolute undertaking. Your lordship may kindly see that undertaking for a minute. They make it very clear that undertake to, please.
When the winding up proceedings are pending, whether who has to pay the tax? General, let's
Yes.
not go into the undertaking.
Yes.
Is anybody bound to pay the taxes as the act itself says that 12 months period?
My lord, we were not aware of the fact that the entire company, my lord, was undergoing the provisions of, my lord, that is where, my lord, as and when. My lord, what I say is, as on the date when I demanded the tax, the reason for demanding this tax was, I found, my lord, the subsequent purchaser came and paid the tax for the relevant year after purchase, as after the sale.
Yes,
Then, my lord, I find from my records that from 2009 to 2015, taxes were not paid insofar as this property is concerned. Then, my lord, kindly see that email which I sent. If my lords may kindly turn to Lord, page number 48 in the paper book. That is application. there, page 48, your lordship gets it?
48
Of the application filed by JM Asset, Financial Asset Reconstruction.
The
47 and 48 are the emails. Immediately after that, my lord, the undertaking,
let's see.
there are three, my lord, there are three emails. The first one, my lord, is, it commences from the backside, 48, my lordship gets it. BBMP tax, plot number 330B, Pina, Bangalore. Lord, we thank you for the first payment of BBMP taxes for the year 2008-2009. They had paid it on 8/4/2021. Kindly see this. For the taxes for the year 2008-2009, please find attached latest BBMP challan raised for the year 2009 to 15 for 1,26,26,121 issued by the BBMP for the immediate payment of property taxes in respect of plot number so and so so and so. Also find attached the receipt of the tax paid for the year 2008-2009. Taxes, my lord, as on that date, my lord, Karnataka Municipal Corporations Act was made applicable. Now this is a first charge on the property. Nobody, my lord, no doubt, the company, my lord, is undergoing the process of liquidation. That will not, my lord, come in the way of me recovering the taxes under my enactment. The provision which specifically talks of, my lord, the limitation period or whatever it is notwithstanding anything contained in any other law. Insofar as taxes are concerned, recovery of taxes, there under that particular provision of law, my lord, 6 years time has been given to me to recover the taxes. As and when, my lord, I came to know of these aspects, immediately, my lord, another notice, and in fact, they were obliged to pay my taxes for the year 2008-2009 also. Having done that, now, my lord, since the amount is more, people cannot, my lord, relegate their responsibilities like this.
My lords, my
Please.
lords, there is one important fact which is missing. My lords, this is very important point. May I submit, my lords?
You can submit.
All right.
This is R1. IOL ಒಂದು ನಿಮಿಷ ಇದೆ.
Can I make a submission, my lord?
No, no submissions at 2:30. Yes,
Please.
we continue with the matter.
Chair number 18. Chintan Chinnappa, case Mahadevan for oil.
As per this 539
530, ma'am. 529.
and 530.
Yes, ma'am.
The revenues, taxes, please read that.
My lord, I'll take it. 531, my lord. In 1A. All revenues, taxes, cesses, and rates due from the company to the central government or the state government or to a local authority at the relevant date as defined in clause C of subsection 8 and having become due and payable within the...
C of subsection 8.
Yes, ma'am. Please see subsection 8 for the purposes of this section. My lord, has it?
Clause
8 for the, yes, my lord, on the next page. For the purposes of this section, 1A is any remuneration in respect to a period of holiday or absence, that's for workmen. B, accrued holiday or remuneration. Then C, my lord, expression the relevant date. Means in the case of a company ordered to be wound up compulsorily, the date of appointment of a provisional liquidator or if such appointment was made, the date of the winding up order. No appointment of, no, I'm sorry, or if no such appointment was made, date of the winding up order. Unless in either case, the company had commenced to be wound up voluntarily before that date. And the case under subclause 1 does not apply, date of the passing of the resolution for voluntary winding to the company. Therefore, 1 applies. This is a compulsory winding up. The date of the winding up order. Date of the winding up order. So whenever the winding up order is made, from that 12 months from that day is the calculation for the purposes of determination of what is the taxes and liabilities of the company. It arrests then. Once it arrests, during the process of winding up, there is no question of taxes and liabilities of that kind. Therefore, if a claim is made,
According to you,
yes,
this liability will be what date?
they have made a claim, my lord, right up to the date of the...
The light of that.
In the light of 530, my lord, if at all. Yes, dates. Date of the order winding up is 4/12/2012. 12.
So 12 months from 4/12/2012 is only what your liability
Yes.
is your submission.
Yes, that's...
Then what is now they raised from what date to what?
They've now raised, my lord, from 2009 to 2015. Well, that your lordship will find that in the letter itself, in that email.
Advocates.
Page number 48, my lord. Hello. Of my application itself. 2009 to 15. Lord, if I may digress for a minute. What actually should be done, my lord, is they must come to the official liquidator and make a claim for that money. There is a process for doing it. The official liquidator will then assess the claim and determine that this is your entitlement. Once your entitlement is determined, during that period, when all claims, my lord, are determined by the official liquidator, they will say how much money we have at the end.
This provision and as per your submission, there is nothing much for the official liquidator to determine because according to you, between this and this only is entitled.
True. No.
What is the term?
Yes. No, I'm not saying that. I'm saying, Lord, it's a slightly different point I'm making. If I am a creditor, I must go to the official liquidator and tell him this is my liability. Official liquidator will examine it and say, yes, this is your liability. Put it in that list of creditors. Ultimately, my lord, when the time comes to distribute dividend, of course, it is really payment, my lord, there is a percentage which is arrived at. Because total claim is 1 crore, 10 lakhs is available. So I can only 10% I can pay for each of them. Therefore, up to the date, that is up to 2012, I'm sorry, up to the date of winding up and 12 months thereafter, out of whatever liability is there, you must see as to how much money you have. If that is the amount of money you have, that is the amount of money you can pay. Therefore, my lord, at best, which is why I said, if that amount of money, which is determined, is they've paid about 20 lakhs to the BBMP, the question of paying for period after that does not arise.
So, as far as that period is concerned, it needs to be paid to the BBMP. He's entitled to.
Yes, my lord, but that is determinative of how much money is there in the company in the first place. Yes, ma'am.
No, in the life of the undertaking, in the life of the undertaking given by you, and that looking at the provision and where it specifies about what is the timeline for the what period you are, no, it has to be like that. Now, you don't have to consider your undertaking for whatever period that is there, and according to them, whatever is outstanding, that will be paid.
This is what I'm saying, Lord. If outstanding exists in law, then Lord, the question is who is to pay. That is first part of it. Because otherwise, what really is going to happen, Lord, is we will be breaching after the auction.
That is long back.
Yes, yes.
That is a long back.
No, I'm not disputing that. It's the.
So as per the act, so you're the only one who is, you're the only secured creditor.
I'm the only secured creditor.
No question of deducting or thing or anything in this.
No, no. Insofar as the money that's come to me, there's no question now.
It's calculated or that.
May I make one submission, my lord, with respect to the interpretation of this provision, since we are on that. The official liquidator, my lord, in practice, how he verifies these claims is with respect to taking the relevant date, which is winding up order, as the date which is relevant for the purposes of consideration, my lord. The company, my lord, when it was functioning, would have incurred several debts, some of which it may have paid, some of which it may not have paid. And one of the reasons for that may have been the winding up order that was passed. So that is why, my lord, for 530, these are the dues that has accrued by the company prior to winding up, my lord. If I may further elaborate on that, when the company was in possession of the land, in this case, my lord, before winding up order was passed, that is of December 2012, they seem to have not paid the tax dues for.
So, well, let's say 2/1/2012 is the winding up order.
4/12/2012.
So, before that, let us say 20 lakh rupees is the outstanding to the BBMP.
Correct.
And
That.
along with that.
Please.
Along with that, from there, from the date of winding up, another 12 months. Whatever is the amount, has to be paid to the BBMP.
Please, my lord. In that, there is a distinction that I am making, my lord. In the example your lordship gave, the amount of tax pending before 4/12/2012 was 20 lakhs. I'm just taking that example forward, assuming that the tax still 1 year after is, say, 22 lakhs. My lord, this 22 lakhs, my lord, will come in order of priority, which will come after the payment is made to secured creditor, my lord. Because it is 530 and 529 payments have to be made first. This 22 lakh will be paid after the secured creditors' dues are satisfied. There is another provision to this. This,
but it's still not satisfied. My dues are not satisfied.
Please.
Undertaking that is given by them.
May I just complete this? After 4/12/2012 till date of sale, my lord, it is a time when it is in the possession of the official liquidator that property tax dues that have been incurred when the claims are being called and when auction process is being conducted, my lord. That portion of dues which falls after 4/12/2012 till date of sale, my lord, will be 476 is my submission. that has to be paid in priority to learned senior counsel's claim as well, because that is the, if I had not paid those dues, they would have attached the property then itself, my lord. That there would have been no property left for sale had I not paid those dues between, at the, please, my lord. Please, my lord, in the sub-rule 3, my lord, I have to preserve that property. One of the ways of preserving property is paying relevant taxes, my lord. The amount that your lordship mentioned prior to 12 months, my lord, that 22 lakhs, they will probably not get in this case, my lord, because that comes after the secured creditors are paid. Just one, just clarify. This is this. Please, my lord. This, my lord, I have to keep the property in a live shape for someone to pick it up 3 or 4 years later. I will incur some costs. The very apparent cost is of security guard, my lord, which I gave the example of. In thousands of cases we pay. The other cost, my lord, when it is the property which is in my custody, that is post winding up order, between that period till sale, it is fully under my custody, my lord. I will have to pay property taxes because that is 476 cost. In 531A, my lord, if I just reread that provision, it stops at relevant date. For that, in that 22 lakhs, that 22 lakhs actually BBMP may not get because secured creditors claim is not satisfied. Whatever is beyond 22 lakhs till the date of claim is payable in the custody of official liquidator as dues costs incurred in winding up, my lord. That is the submission that I'm trying. And it is also having a wide impact. Partly, my lord, because he may not have to pay all 1.29 crores which is due. He may have to pay only that part which has been incurred post 5/12/2012. Please, my lord.
That undertaking.
Please.
So even the. Yes,
Please. He may.
Which order which is passed in company application 343 of 2017. It's a conditional order which was passed.
Page number.
By this court, by this. And DC. Not it is dated 7/2/2018.
Objection.
343. This is the order, Lord, which permits sale, joint sale by the applicant as well as the owner. Kindly see internal page number 4. The pagination, Lord.
It starts at 34, my lord. It starts at 34, man.
Internal page 4. Finally, last 5 lines from the bottom.
In which case it is order?
Lord, CA 343 of 2017.
Yes.
Please.
This is Bopan's order.
Yes, just in 4 minutes. Internal page 4. That is the last page in that particular order.
Yes.
The condition order. Last 5 lines from the bottom.
Got it.
Amount realized, kindly see. The amount realized shall also be appropriated by the applicant only after obtaining leave of this court and after the OL determines the preferential claims, if any. Kindly see this. After the OL determines the preferential claims, if any, in respect of the company. Now, first of all, there must be a determination at the hands of the OL insofar as the claims are concerned.
How it will happen?
No, that is where I am coming to. Now what happens? During the pendency of this determination, amount is realized, he is not supposed to release this amount up till he determines the claim. Now, once this insofar as the determination is concerned, he gives notice to the concerned persons, whoever has got some dues to be paid. Accordingly, notice was also issued to us. Then, this notice was issued in the year 2019. 2019, after this order only, immediately, I cannot recollect that particular order of issuance of notice. It commences from that particular day, immediately after this. Now, in the meantime, what happens? Kindly see, undertaking is taken from the applicant. In this, kindly, I refer to 2 provisions. in this undertaking. It is not the case of the applicant that he was not aware of the dues that is liable to be paid in respect of the property taxes to the BBM. Kindly see that undertaking for a minute, which was given by him on 19/12/2019. This undertaking at paragraph number 2 makes it very clear that the scheduled property is sold. However, the BBMP tax and DESCOM electricity dues on the said property are not ascertained till date.
No,
He was aware of this.
now.
Yes.
The court will ask him to ascertain. If ascertained, how it has to be ascertained.
Well, now what happens?
Then it comes back to what the.
No, apart from that,
What the advocate, on
Correct.
behalf of the OL is saying.
yes. The OL places this entire ascertainment or the claims, a report is prepared and placed before this court in OLR number 147. When this court passed an order directing the OL to release the amount as interim dividend. Now, this was always subject in that report. It was always written that whatever dues, property dues, that is there. Kindly see that. Now, kindly, may I request your lordship to kindly turn to page number 40 of the of CA-299. This was placed on record.
Page number?
Page 40. In OLR 147 of 2019. If my lords can call this particular OLR 149 records, page 40 of the first paper of the application filed by
Mine.
OLR order. In orders in OLR 147 of 2019.
Where do you get that?
My lord, I
My
only
petition,
say this.
in the petition.
In the petition, along with the petition.
Your lordship.
CA-299.
Yes.
CA-299, page number 40 is the undertaking.
No,
My
no.
lord, that is my OL's objections, my lord. That is not the application.
The page number 40 is an order, my lord, releasing money.
This is filed by the applicant, my lord. The book your lordship has is my objections.
In fact, the objection statement filed by the auction purchaser will not, he extracts this also.
This is the CA, 2021 and beginning.
Page 40.
In the CA, page 40.
Last paragraph. The official liquidator has furnished details in form number 21 as required under rule 160-167 the company codes rules 1959. The same is accepted and taken up. This report, my lord, makes a reference to the aspect of, my lord, payment of property dues to BBMP as being undertaken by the applicant. That is what in the objection statement of the auction purchaser he extracts. That is where, my lord, if my lords can always call this particular OLR 149 of 2019 also, you will come to know. Now, kindly, in that, my lord, why I am making this reference is, they were all aware of it. My order of demanding this amount is not called in question before any court. It has attained finality as on today. Now coming before the court and saying that, my lord, this amount I am not liable to pay after having given an undertaking and accepted by this court. My lord, and taking back the amount.
Before the court at that point of time.
I was not aware of it.
You were never participated.
We are not part of it.
Yes, that is what.
Participated.
Yes, very good.
There was no occasion for the court to consider your case. or to even understand what would be, unless you
I can understand that,
article before the official liquidator, why would he consider?
Lord,
what
I
would be
can
the-
only say this much. As on that date, I was not aware of all these proceedings is one aspect of the matter. Merely because, my lord, I am not aware of it.
What the court is saying is, let us now consider your entitlement as per the act. We consider it now.
My lord, what happens is if that is considered, it will be restricted only to 529 now. My claim to the extent of, my lord, balance amount goes off.
You are before the company court.
My lord, the reason is,
You
I
are
am not before the company court.
court.
My lord, I am not before the company court. They have dragged me to this court now. I am a respondent
You
now
are-
in this matter.
Yes.
Now what happens? Now, my
And
lord,
you know, whatever is the rights and the liabilities of the parties will be determined as per the act.
Correct.
Will not be determined whether the dues to a municipal corporation, how much can be recovered, whether there is law of limitation is there, who will pay, those are not the considerations.
those things are not the consideration of the court, but for the undertaking given. My lord, and which is accepted in OLR 147,019. My lord, but for that, my lord, they would not have been entitled for the amount at all. OL would have kept that amount as long as the claims are decided. That is what the order in 343 says. You should keep the claim, you should keep the amount up till you decide the preferential claims. That is the order of the court.
Did you need to say that? You should have made a claim.
My lord,
Where did you make the claim?
my lord, kindly appreciate this. As and when the claims were called, we raised a demand saying that insofar as this particular property is concerned, this is the amount which is liable to be paid by the
Is it
concerned.
so?
No claim is made. No claim is made.
My lord, they have not filed any official claim with this.
No claim.
This
Have you issued any notice to them?
My lord,
We
they
issued
took
a
paper.
public paper publication, my lord,
Calling
which
for
was done in
claims.
the month
That's the
of
correct process.
July 2019, my lord. The last date was somewhere in the month of August of 2019 for.
Okay. You're not said any.
No.
claims to them.
We have not made any claims prior to that. Not,
That's the
then
end of it.
I come to know that an undertaking is given by the applicant. In that undertaking, the applicant is completely aware of the fact that the assessment or the dues as such is not yet come to an end. That is the undertaking. Kindly see the undertaking for a minute. Your lordship will get it at. Note in the objection statement, 2 undertakings are produced before this.
Yes.
Kindly turn to the undertaking dated 19/12/2019.
Page 66 of my objection.
Kindly see, turn to next page, after point number 2. After point number 2. Now therefore, JMFARC undertakes to pay the excess amount, if any, towards the property tax and electricity dues so calculated by the concerned authority. In the event of the property tax and electricity dues exceeding 20 lakhs. Now, my lord, can they get away by this from this clear undertaking or absolute undertaking which is also placed on record before this court when they took back the money, my lord? As dividend, as interim dividend or whatever it is. But they cannot decide from this aspect of the matter. That is where, my lord, I make a submission that if my lords were to hold that 529 is made applicable now, then, my lord, I lose my right of that property taxes are concerned for that particular period. In view of the undertaking given by them.
When nobody has to pay the taxes, as per the winding up, as per the Companies Act, how do you pass on the liability on anybody?
Lord, by virtue of this undertaking.
That I'll answer.
Now, by virtue of this undertaking, my lord, they are liable to pay because reason is, my lord, they make it very clear that as and when the demand is made, what I can understand from this particular undertaking is as and when the demand is made by the concerned authority or fixed by the concerned authority, we are liable to pay if it is in excess of 20,000, 20 lakhs. Because up to 20 lakhs, OL says I am going to pay. In excess of that, my lord, they are liable to pay.
That 20 lakhs also I've deducted from that sale consideration. I'm not paying out of the pocket, my lord. The only sensible approach that I can see, my lord, is to say the dues that have accumulated prior to winding up order as something which falls under 531A and consequently behind the 529A. And the ones that have accrued post winding up order but pre-sale, my lord, as something that needs to be taken care of OL, which independently he has no source to do. He is doing it from the sale consideration that has been obtained from the property.
They paid.
It's already paid. This is in excess of that amount, 20 lakhs.
You have paid to them.
Please, my lord.
Yes, 22 lakhs or something.
20 lakhs.
20 lakhs.
Whatever with the interest earned with. My lord, the.
Claim. They can't make a determination of a claim.
My lord, the.
BBMP has to make a claim, my lord, in the form before them, then they'll make a determination. And there's a time limit for it. If you don't do it within that time limit, unless the court grants time, there's no question of the OL considering it. That claim is lost forever. That's the law, my lord, and so far as that is concerned.
They are taking advantage of.
I'm entitled. I didn't make the law, sir.
Law.
Then that matter.
To pay the amount, now come and say that law says something like this.
What can I?
In any event, my lord, delay condonation applications are never objected to us by us, my lord, if they file it, but they have to file it. In any event, my lord, the BBMP has to give details of which part of tax has accrued till what date. Then we have to make that segregation.
Come, will allow that, and simultaneously this also will be disposed of. That's the only thing.
I'll take instructions, my lord, insofar as that aspect is concerned. And
If you can't, then
what happens here
if you have
is,
no instruction
I can only
on
say.
that, no. If you have no instruction, then we have to allow the.
Lord, I'll take instructions. Lord, I'll communicate this to my commissioner and I'll get back to the lord.
Whatever, if you want to file your claim for them, we'll give you that time. And also, what are the parameters, what they have to consider, also will be fixed by the court. And accordingly, it will be determined.
In fact, this court, my lord, on earlier occasions had also permitted me to proceed further and attach the properties. What is the order of the court? Even that order is 1021.
That is an interim order, not the final order.
So far as the opponent is concerned, in that it clearly says that the subsequent purchases has nothing to do with the taxes and other things.
Correct.
How can you?
No, in respect of the taxes prior to it, prior to the sale.
Where is that order?
Correct. It's prior to sale. Absolutely. After sale, he only has to pay taxes.
No, prior to question is, it is prior to sale who has to pay.
That is what is.
So this undertaking, my lord, he is supposed to pay this amount.
Or when you're supposed to be vigilant and you don't do what you're supposed to do, and at a subsequent point of time you come and now it is for the court at least for limited your request also. So your client can't put forth that argument before the court. Where is that order that you sell the property or proceed against the property?
Some
after 2019,
my lord. It was some oral statement made in court saying if you want, you proceed.
My lord, after 2019, after I took possession of the property, I have paid the taxes. There is no pending on my side, from 2019 to date. 14.3.
There is an order at the hands of this court permitting me
You have the orders?
to proceed against the property.
There is no 14.3 order. There is 7.3 order.
Open the case status. No?
These are tabs. They have made the BBMP being statutory property tax. The BBMP has all rights and remedies available under the BBMP Act or the Karnataka Municipal Corporation Act, depending on the period for which the property tax due.
It's all open, my lord.
Only that whatever is available to you.
Yes.
If it is.
Correct. Now my order is not covering.
Yes, sir.
What
Yes,
I'm
sir.
saying. My lord, whatever order, my lord, whatever
There is
demand I
no
have made.
positive direction. You have all the remedies whether the court says or not.
This
That is
permits,
all
my lord, I will
subject to
proceed
the-
further in accordance with my act. Permit me, my lord, I will proceed against the concerned property, my lord, because this is the first charge on the property. On the property taxes, my lord, first charge.
Lordship, sir.
My lord,
Reserving it.
since that there is already an order in accordance with BBMP Act, whatever I am supposed to do, I can do it. Then, my lord,
We've
my
argued the.
My lord.
Up to him.
No, your presence before this court is required for the reason you'll be getting that amount now. Or else you won't be getting that also. The request of then counsel for the then counsel referring to the BD until this matter next Thursday. So that again I don't have to hear all this.
Oh, let my lawyer Lordship, I will reserve this note, and if he wants to make an application, he can make an application. Sorry. Right. Very well. Next week, Lordship may have it then.
Gladly to, sir, because now, my lord, my commissioner is running around in Supreme. That's a difficulty I have.
2 weeks will not be possible. And it will be
Next last.
we'll take up this matter on board by the time.
Good.
Whatever you want to do, tell your commission if you can't do, court will pass on. Because after wasting this much of judicial
I
time.
can understand that, lord, if my lords can accommodate me for 2 weeks. From 2021,
I mean, 2
my
weeks,
lord,
right,
they haven't dragging this matter like anything.
30,
How many adjournments they
10
have
days
taken?
ago.
No, finally they have taken a decision.
Yeah, finally they have come.
And you know, it's not about you people, it's about the court's time. Having substantially spent the time, just like.
No, I can understand that. Grant me 2 weeks time.
Third, so getting time. Third.
10 days. It's 10 days.
But I want 15 days at least. I have to immediately install. I'll communicate to the concerned authorities and then have to prepare the applications also before your lordships. That's the reason. I'm sorry. You're only inconveniencing me.
This is planted on 3rd of March.
3rd of March.
Difficulty is from 6th or 5th of February till 1st of March, personal inconvenience to the court.
Sorry for that.
It'll be 4th. Lordship may have it. We'll see. If it happens, we'll try, my lord. Otherwise, why? After the Lordship is spent.
On 3rd.
3rd of February. Great.
Yes, Nick.
Pass over matter, serial number 1.
Yes.
No, the morning other side was not present, Lord.
Team Prabhakar for R3.
Lord, this 789 of 2004 is filed by the official liquidator under section 454 for non-filing the statement of affairs. Lord, we have issued the notice, Lord. Lord, the respondents did not appear, Lord, even despite of due service. Therefore, an application under section 82 of CRPC was filed. Proclamation was initiated. And Lord, in last hearing, Lord, this honorable court, they have appeared and they undertook to undertake.
Short time on the last.
No, Lord, I am not. Yes.
My lords, they have come after 20 years. The tracing them, they have filed an application.
Yes.
Yes. They have come after 20 years and they have filed an application saying that the company went in winding up into early 2000. Now, after 15 years, we are coming here. You give us the inspection of the documents in OL office, which we have taken in custody through ourselves. And they have made ROC also a party whose documents are available on a public portal that he should also submit the balance sheets and all. So, my lord, this is a delaying tactics. We are ready to give them limited inspection of what exactly they need. We have no objection even after 15 years. But if they say that let us do the inspection of the whole documents and all, my lord, they should have a purpose behind inspecting the document. That is not forthcoming. They are just saying that since we are coming after so many years, we need inspection. My lord, that application would be CA 201 and 202 of 2024.
The problem is to find out where it is.
My lord, sorry, my lord.
CA-20.
1 and 2, my lords, both are same nature, my lord.
The applicants are in a position of different. To submit the statement of the facts. And you got the inspection of the records of the office of the respondent number 182. So what you say, like, what is that you are asking?
Yes, my lords, I'm asking, they are asking for a complete phishing.
Complete?
Phishing of the documents. I am just saying them, if they have any purpose with a particular document to file SOA, Statement of Affairs, they can give a list. If those documents are available, are in our custody, we'll provide it to them. Otherwise, we'll give the reply.
We want them to
Furnish a list of what all they need. Yes, my lords. If it helps them to furnish SOA, I have no objection.
The one of very medical common. The one who is preparing for entry was 24 years ago. Yeah, they are not in possession of any of the documents. As the applicant are made in custody of the documents, not as they are not obtained any soft copies of such records. They wanted to file a statement of facts as section 454 of the Companies Act. For that purpose, they want to carry out an inspection of records at the offices of the official liquidator as well as the register of companies. The matter was called in the morning as there was no representation on behalf of the respondents.
Appearing for respondent number 3, your lords.
Who filed you appear for the?
Respondent number 3, your lords.
Who is respondent number 3 in this? There are only 2 respondents.
Serial number.
That be the original statement of affairs which our office has filed. This is
So here about the application.
only 2.
He appears for whom here?
R3, your lords.
One of the respondent in the main.
Main.
789.
There is no representation. Nothing to do with this 1 and 2 applicants.
This application here.
There was no representation on behalf of the respondents. As such, the matter is passed over. Even in the afternoon also, there is no representation on behalf of the respondents. Next paragraph. Then counsel according to the submits that they have come before the court after 24 years after the winding up proceedings or initiated. It is nothing but nothing but to delay the proceedings. It is submitted that if the respondents, the applicants come up with the documents which are required by them for filing the statement of affairs, they'll furnish the said documents if they are in custody of the official liquidator. Next, though this application itself is filed, with a delay. And I will filed the application. There is, the applicant has not even come before the court. Considering the reasons that are stated, this court deems it appropriate to, go with the, this court deems it appropriate direct the applicants to furnish the, list of documents to the official liquidator. And, as per the date furnished to the official liquidator, if they are, in the possession of the official liquidator, either the applicant can inspect the same. This is matter on that for furnishing of the details of the documents 1 week from the date of, from 1 week from today. Within 1 week from today, they shall furnish. Thereafter, the official liquidator within 1 week from there on shall give a date for inspection. This is matter on 11th of March. By any chance, if within 1 week the details are not furnished, no further time will be granted to the applicant in both the cases, in both the cases. That is
CH-20 of
201 and 202.
Till number 5.
Please, what I said. An application report on 4/7/2024 is also. 4/7/2024.
Yes.
Whereas counsel appears from the respondent 2 or 3 submit where the respondent 2 or 3 would rectify the defects in the statement of affairs the next day. It is made clear that in the right of the presence of the respondent number 2, only on bailable warrant. The bailable warrant has been issued against the respondent number 2. And he was directed to be present before the Sarva Court on the date of hearing. Even despite he did not. And that apart, the Sarva Court has also specifically directed to furnish with an affidavit along with the address proof, latest address proof, contact numbers and mail ID. They did not even comply with.
Concerned police department has given a report. There the old address has been given in voter ID, electoral card, everything is the old address has given. The correct address has given, definitely they'll proceed to arrest.
I request my kindly we issue non-bailable warrant. Because it's a too old matter, not eligible. Winding up order has been passed on 11/3/2014.
This is 5. 5.
Serial number 5.
Who is Mr. Vijay Kumar?
The earlier old government advocate.
Well, government advocate's name will also be printed in the cost title.
Sometimes only.
Police purpose, expedition of day. And for sometimes not for find out the law. That is the reason it was mentioned.
Sometimes.
Otherwise, there is no room.
If they furnish a fresh address, definitely they will proceed.
We'll see next week. This is matter next week.
Please, madam. Like.
Yes.
Till number 19.
Apologies, my lords, I'm proxy counsel appearing for respondent number 2. The counsel on record had an emergency and he had to leave, my lords. I pray for 3 weeks' time to file objections. They filed wakalat only on 16th, my lords.
R2 is the son of one. He has sent me a letter to me stating that I am not well. I will given 4 days time, but I will come with you. But you can give that letter on 19/11.
It is submitted that the respondent number 2 is unwell, and 1 is no more. 1 is no more, and respondent number 2 is unwell. This is matter on 17th of March. Yes.
Number 20. Madhavan sir.
Yes.
And for respondent number 1 to 4, your lord.
Venkatesh sir.
Yes. Yes.
But company's property, particular operation, the government told 8 acres 20 acres to person who is not able to sell the property, he has sold the company's property.
No, come to the causes. Non-compliance of office objections raised on statement of objections filed by counsel for R1 to R4.
I am for R1 to R4, Your Lord.
That's what are you going to do?
We will comply with,
When?
kindly a week's time may be granted.
Statement of objections filed by counsel for R6. Letter dated 18/11/2023 received from police inspector.
That objection is filed by 1, 2, 3 and 4, according to the objection which I have received. Objections, statement says that filed by 1, 2, 3 and 4.
No, anyhow, we are not on that.
Yes.
What is this letter dated 18/11/2023? Received from police inspector Narasimha Raja Police Station.
That is
Memo dated so and so filed by OL. Steps to be taken in respect of unserved R7 as per memo of service filed by OL.
7 is.
What is this memo?
That memo is not that. It is 12:1.
So now you have to take, again, summons have to be issued in respect of which respondent? There is no para in the memo.
Page 4.
You're referring to the memo dated 7/12/2023.
I will come.
So as per that, already the respondent number 1 to 4 are already served, represented by advocate. And R6 is also served, represented by advocate.
Yes.
R5.
R5 and 7.
R5, page 2, as per the postal track observed that item delivered.
Where is that?
Service. That's sufficient. The tabular column.
In the tabular column, it shows that acknowledgement not received.
Respondent number 5.
Left, one is left.
12/1/24.
We'll be able to complete all these orders fast, provided everything is on the fingertips. It's all because no fruitful work, looking at notices except that, nothing. That's what, it has to be like. It says neither the undelivered nor acknowledgement card received. Not that it is delivered, item delivered is not what.
Item number 5.
Remarks, as per the postal track, observe that item delivered. So 5 is served.
Yes.
Then 7?
7, madam.
Given their email ID of the MCA token which has to be connected. The summons returned with postal remark left, but that mail, we have sent the mail and it has been sent to email which have they given to the Ministry of Government. So So my lord, it's up to my lord to consider if
You have filed a copy of that, whether it is functional, that email.
if they change it and the company is found, it is deemed to.
The notice, the respondent 1 to 4 and the 6 are represented by the advocate. As far as respondent number 5 is concerned, as per the postal track and as per the memo filed by the OIL, item is delivered and the notice is served on the 5th respondent. When it comes to the 7th respondents, the summons sent were returned with the postal remark left. And the official liquidator has sent the email as furnished by the respondent number 7 with the register of companies on when?
That
On
detail-
6/12/2023.
Then, my lord, that detail is not part of my,
It says 6/12/2023.
my lord, that whole details are not.
Then file it to say that the notice is,
Don't want my lord. Not give any
then we'll stop. As far as the 7th respondent is concerned, it is stated that they have sent the email as per the address produced, as per the address furnished with the available with the register of companies, furnished to the register of companies. The OIL shall place before this court the said mail sent to the 7th respondent. This is,
I have to confirm whether it's registrar of company with body corporate register, mail we have attached, my lord. But through what we got that email ID, that I have to confirm and submit.
I have to place before this court, what is the mail ID that is furnished, that is with the register of companies, and whether the mail is sent to the particular address. This is matter on 18th of March. Yes,
Number 21.
The date, not urgency, not any
Okay.
shorter date. I am
which case?
this case.
In 20?
Yes, ma'am. Any short, because my property is
It will
involved
be
and,
next week.
Blood.
Court has no difficulty because notice has to go.
blood, that's what, blood. Blood,
Respondent number 7.
R7 is shown as blood complete in liquidation. Blood, if at all it is the
Next
OIL
week. Thursday, yes,
31.
30th,
31.
30th
30th,
of this month.
Sir,
yes,
Great.
yes.
Number
Can I
21.
make one
Prakash
submission in
KA
the same matter? I am for respondent number 6, my lord.
for applicant.
In consent to the prayer at Annexure C, the order passed by the learned single judge, we have
Yes, ma'am.
filed a SLP before the Honorable Supreme Court, madam, which is pending. And the Honorable Supreme Court has directed the notice to the respondents. That is the present state. Serial number 20, serial number 20.
Blood, there is no interim order. Blood, of course, blood,
No interim order.
There is no,
blood,
What you have filed before the Supreme Court?
the order challenged by the learned single judge, my lord, dated 5/12/2000,
Then
2012.
how can you go to the Supreme Court?
That order is against me, hence I have.
No, they say that there is no order as that is passed now.
no, not in this, blood. Blood, all these matters arise out of a blood company petition. Thereafter, blood, it was taken in appeal in OSA.
Any of that order, does it have any binding on this? If in that case, we have to adjourn it,
Could touch upon my lord.
then we'll have it on 10th of March.
Very well, please.
Sir, number 21.
Court has no difficulty.
Lord, I understand, Lord.
Yes,
Great.
10th of March.
For the applicant.
21. Prakash KA for applicant.
My lord,
Yes.
this application is filed for a direction to the respondent official liquidator to execute the sale deed in favor of the applicant number 1, my lord. In line with the order passed by this honorable court at Annexure
Where is
F,
the order?
Annexure F, page number 15. My lord. The relevant portion is at page number 51.
Yes.
Page number 50, my lord, para 13.
The applicant's father initially filed an application for allotment.
No, that you can tell. First, let me understand what is the application.
Yes, ma'am.
Yes,
Page number 50, my lord, ink page number 50,
yes, please read.
para number 13.
Yes,
Having heard the learned counsel for all interested persons a learned counsel for the official liquidator, and having looked into pleadings and papers leading to the present development, I am of the opinion that it will be in the interest of the creditors and other stakeholders to permit the official liquidator to effect sale of the houses in occupation of each of the.
Directed to execute the sale, the
Yes.
official liquidator was
Yes.
directed to execute the sale deed
Yes,
on
ma'am.
receiving the sale
Sale
consideration.
consideration.
When was this order?
It was passed on 16 July 2004, my lord,
16th July?
2004.
Hmm. When did you pay?
On 16th September 2004, the
Hmm.
next page is the demand draft copy, my lord, DD copy.
Hmm.
16th September 2004, I paid the DD,
Hmm.
page number 52.
Hmm.
Thereafter, my lord, Annexure H, page number 53, Justice Bopanna has also passed an order in favor of my father. He passed away now. That's why the son is before your lordship for a sale date.
Why your father filed another writ petition for the?
Because there was a delay in getting the sale date, that's why you wanted.
Then what was the order on 9th
Uh,
March, 9th March two thousand
Yes,
twelve?
9th March also, this honorable court directed the official liquidator to consider the
When your father died?
He has died on, well, not produce the.
Twenty-six, some date. 21/7/2023.
This one.
Then why it is not executed from 2012? Ex-employee?
Of the company, which is under liquidation, who owns these flats and they were employees of the company. So since they were residing there, whoever was residing there, this order was given.
Yes, yes.
Now he has to give two proofs, my lord. One, they were employees of the company, that is not a problem, they are verified. Second proof is that he was residing in a particular flat number 131/P. Now that proof is not there in our record. If he has given, we are sorry, we are not able to find it, he can give again. Or if he has not furnished, he can furnish.
It is there. Annexure C is there, page number 11, it is there. Page number 11. Annexure A is my appointment order, page number 8. Annexure C is allotment letter, house allotment letter. Yes.
What else you require? Page number 11.
Annexure C.
But why was it not done?
Yes, sir. Yes, sir.
But I'll not know why it was not done. It is given in the files that basically this was allotted to his father. And my lord, he has come as the.
Even for the father also you didn't do. Father died in the year 2023. Order was passed initially on 9th March 2012. No, 16th July 2004, then 9th March 2012, another order is passed.
Sorry for my office, but it should have been done.
So what is the timeline now? 1 week we'll do.
1 month.
My lord, will start the proceeding immediately. He has to give.
Outer limit, whatever it is. Now, from his side, he has done what is supposed to be done.
Yes.
No, that he will do. That also will fix a
I do,
timeline.
yes.
How can one will wait from 20?
Within my part, I'm saying, once he supplies the sale deed, I'll vet it within 2-3 days and furnish it back with a sign and letter to be given to the registrar. So I need a week from the day he supplies it.
Yes, ma'am. No problem.
So what you require is a draft sale deed.
Draft
From
sale date.
side.
Yes, we have.
CA number. (295/2023) is filed in the COC company petition number 112 of 1994. Seeking a direction to the official liquidator to execute the sale deed in favor of the applicant number 1 herein. in line with the order dated 16th July 2004, passed by this court in company application number 12 of 2002, 967 of 2002, 511 of 2001, 2514 of 2001. This court in the batch of applications, what is your application, your father's?
No, it was not there. It was for all the 300%. In this, only some employees came to this honorable court in 2004.
Was
There-
he part of that order? His father, 16th July?
That order, this is Bopanna's order, my kindly.
Yes.
Lord, in this regard, the application papers itself would indicate that the official liquidator in fact has addressed a letter to the applicant guaranteeing for certain details to establish their claim. This would indicate that the official liquidator has not rejected the claim of the applicants, but has already indicated that the applicant should produce the said documents. It is needless to notice that all the documents sought for by the official liquidator may not be available with the applicant. Considering the fact that they are employees belonging to the lower state of, and there is a possibility of not maintaining all their documents. However, the basic fact that matters to be established by the applicant is that they are not only the employee of the company in liquidation, but also the residents of the quarters. And in this regard, it will be open for the official liquidator also to make appropriate inquiries to find out the correctness of the claim put forth by the applicants. Hence, at this juncture, a positive direction to execute the sale deed.
I've seen that. Ultimately, what even for the judge, even as per this order also, if he is entitled as submitted by the OL, he has to have
Yes.
that his father is an employee. They were residing in a particular thing, which they have already placed before this. You verify it.
Yes, yes.
Verify it.
Very good.
The order is?
For the people who were residing in those quarters. The original order says the people who were residing in those.
How do you determine after 2000
My lord,
from
they-
there to?
Will be in the name of the person who is residing.
My lord, this honorable.
No, latches are on your part, which you have not, which you have failed to do, and expect them to get something, what is there? No,
In case they have any extra document,
Aadhaar card.
they can give it
I
to
produce the
me.
Aadhaar card. Annexure K is my Aadhaar card, wherein it shows my.
no, we'll have this matter tomorrow. Look at whether he has produced all the documents or not. We'll pass a positive order. It can't go on like this forever. Tomorrow.
Yes.
Cell number 22.
Please, madam, appear for.
Responding in this case, matter may be adjourned to the next week, because senior counsel is held up
Any urgency?
other matter.
This is matter on 10th of March. Yes, next.
Much of it.
23. Ashwin Kumar.
I appear for the applicant. I
Yes.
appear for the applicant in this case, my lord.
Yes.
I made this application for continuation of delay, my lord. The company was wound up in the year 2010.
Hmm.
The amount due to the creditor is 27,64,352, my lord. There was a paper publication in the year 2016, but it never came to my knowledge, my lord. So I came to the knowledge about the
Are your objections
winding
to
up
that?
proceedings only.
My lord, we have one thing to say, we have no objections to these kind of delay condonations. But Rule 178 says whatever has been decided or adjudicated up till now will not be disturbed by these kind of claims.
Let's look at Rule 1.
Rule 178, Company Code Rules 1950.
The rules are called?
Sorry, my lord.
Rules are called?
Company Code Rules 1959 in law.
You're referring to Rule 170?
8.
What
May I
it
read,
says?
my lords?
Hmm.
My lords, right of creditor who has not proved debt before declaration of dividend. Any creditor who has not proved his debt before the declaration of any dividend or dividend shall be entitled to be paid out of the any money for the time being in the hands of the liquidator available for distribution of dividend. So, my lords, any dividend or dividends which he may have failed to receive before the money is applied to the payment of any future dividend or dividends, but he shall not be entitled to disturb the distribution of any dividend declared before his debt was proved.
No, that activity is already, that
My
exercise
lord,
is
that
already done.
it has been done. Mostly it has been done. Whatever is the money or no money, they can file the claim. I have no objection to their condonation. But as per rule 178, we'll go by it. If we have any money, through that, we'll try to decide. If we don't have, it's over.
Yes. Yes, madam.
Yes, my lord. I need to look into the rules and I'll make my submissions, my lord. Kindly a week's time may be given, my lord.
For that, a week's time is not required tomorrow.
Much obliged, my lord.
Serial number 24.
My lords, in serial number 24 and 25, I'm appearing for the respondent. I pray for 2 weeks accommodation, my lords. We have already filed our power, my lords. We'll get the instructions and we'll file our objections, my lords.
Any urgency for you?
No, my lord. My lords, from serial number 24 to 32 would be similar kind of matters of 446. These same, my lords.
Till 32.
Yes, my lord.
This matter is on 19th of March
Please, my lords.
at the request of the respondents.
Serial number 33.
Don't have a copy of this application, my lords.
No representation. This is matter on 24th of March. 34.
34. 34. Tika Raghavan.
My lords, this is an application filed by one of the ex-directors of the company for revival of the company. Now, my lords, there is a judgment in the case of Megal Homes. I have given the list of authorities also. They are coming after 34 years to revive the revive. And the only property in the company is a land. Now, my lord, that judgment specifically says that any revival should not be used to take away the property owned by the company. Now, my lord, land can be purchased anywhere. There is nothing to revive there. Further, my lords, they have done an OTS with the financial institutions of the state, KSFC and KSIDC. And my lord, beyond my understanding, they have agreed to the OTS when they have a security under their hand. They are agreeing for a much.
Your objections to this?
I have filed, my lords, given list of authorities.
Representation.
My lord.
For the petitioner. This is matter on 21st of April. Yes,
For the applicant.
Yes.
Sorry, sorry, I had some other matters, so I have to rush to.
Which
yes.
one? 34?
My lord, the application, see, I am the promoter and the majority shareholder of the company and the director. My lord, there is only the asset of the company is KADB leasehold land. And my lord, we are entered into an agreement with the KSIDC and KFC. My lord, they are the secured creditors for one-time settlement, my lord, and we paid substantial money. And also we are in the process of, my lord, getting the assignment read in favor of one of my companies, my lord. That is understanding. So that is done, my lord. The employees' dues, my lord, we already settled. And my lord, that's a small amount, my lord. Apart from that, my lord, there is
34 you are referring to?
34, madam.
That is recalling of the winding up order.
Yeah, yes, my lord. See,
When was the winding up order?
Winding up on, my lord, more than 20 years, my lord. I agree, my lord. And this official liquidator also not able to sell the property because the KSFC is the secured creditor. They are standing outside the winding up order. And the property of the company, my lord, only leasehold property, my lord, given by the KSID, KADB, my lord. There is no absolute sale deed also in favor of the company. So that reason, my lord, now, my lord, the company was in the business of, my lord, building the best chases, my lord. Now, my lord, we are in the process, my lord, reviving it. We have an offer also from the Tata Motors, my lord, to set up a factory. But actually, my lord, we could have come with a detailed scheme, my lord. So I will do one thing, my lord. We will discuss with I will take instruction. My lords may have the matter on next week. So we'll file a comprehensive scheme, my lord, if it's instructed. That is, my lord, that's objection raised by the official liquidator also.
We'll decide it on 30th.
Please, my lord, much obliged.
Yes, next.
Serial number 35.
Your lordship,
If I appear for the
I,
original petition.
I appear for the respondent. We've issued our NOC in these matters.
Lord, this is once again an application filed to revive the company, my lord. After 4 years after the winding up order was passed. In fact, per se, it is not maintainable because it's filed on behalf of the company after the liquidation order is passed, not even filed separately by an ex-director.
In that you have given up a color.
We've given up a son.
So what did you do? You filed a memo of retirement?
We've issued an NOC. We haven't filed a memo of retirement.
That you have to do, you're supposed to do that.
Then a couple of days time to do that, your lordship.
Lord, same submission.
Any
is
order in
made.
this? Any interim order?
No, there's no interim order, my lord.
No, she doesn't. Well, 34 and 35? Next Friday it will come. Not Friday, 30th Thursday. And by the time, whatever you want to, or whatever, when you have issued, have you issued a notice to him?
Yes,
And you have to file a retirement memo?
No, memo of retirement we haven't filed. We just issued the NOC.
There is a procedure, tell your senior and file a retirement memo. Yes.
Obliged.
Serial number 36. A. Murali. Petitioner.
36, appearing to the petitioner. It's a case that's before this honorable court for the purpose of stamp duty adjudication.
Stamp duty adjudication.
Please, my lord. The scheme has already been sanctioned in the year 2011 itself. In response to my affidavit and schedule of assets, the state government has filed a valuation report, and I have filed my objections to that valuation report itself. My objections are basically on 3 limbs, my lord. My first limb is that I have paid stamp duty in the state of Gujarat and state of Maharashtra. That has to be set off against the stamp duty payable in state of Karnataka.
Let's see your application.
Please.
My humble submissions, my lord. Stamp duty has to be paid. I'll seek some instruction in this case, my lord. Next week it may be taken.
You already filed your objections. You got already your instructions. I think he's saying you're filed.
Please, my lord, they have filed a valuation report, my lord.
But still it's written here, the 1,75,00,000, some changes, the stamp duty has to be paid.
No, that is to be paid. Whether he has to pay it or not, court will decide. You
Please.
find your, whatever instructions you are placed before the court. Yes.
Please, my lord. Reference may be made to the valuation report itself. Has been filed by the state government, my lord. This is a valuation report that's dated 27 June 2015.
No. Let's see your application first.
Please. Lord, it's an affidavit that has been filed by the date of the affidavit. On 10th June 2017, the day I filed my affidavit. In my affidavit, my lords have the affidavit.
There should be some chronology. It should be by way of dates. It should be by way of something. Yes, mister? It has to be pinned as per chronology of dates at least. Every time when the advocates are referring, the court time itself is taken for looking at where is that. What is the date?
10th of August 2012.
10th of August, yes.
Please, ma'am. This is the affidavit and schedule of assets which I have filed.
Hmm.
My lord, the process is once the scheme has been sanctioned by this honorable court, is for the purpose of stamp duty adjudication. In response to the same, I have filed my affidavit and schedule of assets, detailing clearly, my lord, all the different assets that have been transferred during the course of this scheme. The scheme of arrangement has 4 limbs, my lord.
Use the mic. Yes.
The scheme of arrangement has 4 limbs, my lord.
You have to switch on the mic also.
Apologies, my lord.
Yes.
The scheme of arrangement has 4 limbs, my lord. It involves 3 schemes of amalgamations which are taking place between transferor company 1, 2, and 3. And it also involves reorganization of share capital of the transferee company, my lord. Once the scheme has been sanctioned by this honorable court on 19th of August 2011, I have filed my affidavit and schedule of assets. In response to the said affidavit and schedule of assets, the state government has filed a valuation report, my lord. That valuation report is available at...
It is there. It's there on the top of the file. I can see.
Please,
that.
my lord. I have filed my objections to this valuation report on this.
That first we'll look at.
Please,
is
madam.
That according to them, you have to pay.
Please, madam.
Come to page number 2 of their objections.
Please, madam.
Yes.
My lord, in their valuation report, they have valued certain immovable and movable assets of the transferring company. Now, my submission in terms of this is that per se, Article 24 of the Karnataka Stamp Act, it does not say that.
First we look at it. What are the properties?
Please, my lord.
Where are they?
Please, my lord.
How they have valued it?
So the government in Karnataka, my lord, has jurisdiction only to value the properties that are situated in the state of Karnataka. In response to the same, they have valued immovable property and certain movable property, my lord. My lord may come to page number 3 of the valuation report.
Yes.
There they have specified that there is certain immovable property, including land and building. And they have also said that there is no movable property that is subject to this valuation, my lord. My submission in terms of immovable property is that all of this comprise under the ambit of leasehold rights, my lord. They are per se not freehold property. Article 24 of the Stamp Act, it says that stamp duty will be applicable on the transfer of immovable property within the state of Karnataka. That does not go to include leasehold property as well, my lord. In fact, in my objections, if my lord may have my objections.
Or dated?
Objections have been filed on 7th of January 2016, my lord.
7th of January?
2016, my lord.
This valuation report is on 19/9/24.
No, my lord. It has been filed in 2024 via memo, but the actual valuation took place in 2015, my lord.
To this you have filed in
I have filed objections to this in 2016 itself, my lord. It's the same identical valuation report which has been subsequently furnished via memo, my lord.
(17/8, 2016).
7 Jan 2016 is the date of my objections, my lord.
It should be application. If there are any objections to that, main application, objections, IAs, how it should be. Yes.
Please, my lord. In my statement of objections, I have detailed my various objections in terms of the valuation report that the state government has prepared, my lord. I would like to take your lordship's attention to an error apparent on the face of the record of the valuation report itself. If my lords have page number 3 of the valuation report.
Yes.
My lord, the state government says that the total number of shares issued under the head of valuation of shares. It is stated that the total number of shares is 1,75,59,174, each bearing rupees 10 per share. So the total amount that they've arrived at is a sum of 17,55,91,740. On the very next line, the state government says the stamp duty payable is 1% on this sum of 17,55,91,740. The state government says that this sum is a sum of 1,75,59,175. My lord, 1% of this sum of 17 crores is not 1.75 crores. They have taken 10%, my lord. Error apparent is that even if we go by the valuation which the state government is saying, including the method which the state government has specified, it is a sum of 17,55,917, my lord. That is my first submission, my lord.
So you're okay with that 17 lakhs?
No, my lord. Subsequently, I have my objections in terms of the immovable property that's been valued, my lord.
No, as far as shares are concerned.
Yes, my lord, but the catch in Article 24 is, it says either in terms of the value of immovable and movable property that's transferred within the state, along with the stamp duty applicable on the transfer of shares, my lord. Now, if I do not have a determinate amount in terms of what is the consideration for the transfer of shares, and I'm disputing the valuation that has been done in terms of valuation of property, then this either or scenario of deciding whichever is the higher amount, that itself is called into question, my lord, is my submission. My lord, I may choose to address this matter on merits, but my lordship may even direct the state government to at least furnish a valuation report where this error apparent on the face of the record is corrected, my lord. Then I may argue this matter on merits, my lord. In terms of the contentions I have,
No, if you want to argue, you can continue. As far as that is concerned.
Please, my
no,
lord.
it is- It's a simple typographical mistake.
Please, my lord.
The
That,
can anyhow look into it.
please, my lord. So that is contention number.
Themselves said 1%.
Please,
So
my
what
lord.
is 1% of 17 crores?
It comes up to a sum of 17 lakhs, my lord.
Mathematical calculation.
Please, my lord. That is my submission number 1, my lord. My second submission is, if my lordship looks at the table right above, it talks about the valuation done in terms of immovable property, my lord. My contention is that this immovable property pertains to certain property which the transferor company had owing to a lease cum sale agreement which was entered into with KIDB. This lease cum sale agreement, even till date, has not resulted in a sale deed. It is only a leasehold right which I hold under this. Now, my lord, Article 24 of the Karnataka Stamp Act clearly says that it is only stamp duty that is leviable in terms of the transfer of immovable property of the transferor company situated in the state of Karnataka. Now, I do agree that this is property which is situated in the state of Karnataka, but the question before this honorable court is that whether a leasehold right would amount to immovable property per se. My submission is that any leasehold right does not amount to immovable property, and it is only freehold rights per se that need to be considered by this honorable court. My lord, even going by simple logic itself, in the instance I'm forced to pay stamp duty on a leasehold right which has not culminated into a freehold right, there are various conditions which are specified in the KIADB agreement.
So the whole gamut of this litigation, what is that you are getting out of this?
No, my lord, it is only, the scheme has been sanctioned, my lord.
Yes.
It is only determining the amount of stamp duty that is to be paid on the scheme.
No, by virtue of the scheme, what is that you are getting?
There are certain transfers that have taken place in terms of transfer, 3 transfer companies, my lord. 2 are situated in the state of, one in the state of Gujarat and one in the state of Maharashtra. I have already paid stamp duty in the state of Gujarat and Maharashtra. Now it is only in the
That scheme?
Please, my lord. If my lords has my memo along with annexures, this is a memo I have filed on 17th August 2016, my lord.
17th August 2016. Yes.
My lord, in this, on page number 7 is where the scheme pertaining to this arrangement has been annexed, my lord. The object of the scheme is in the preamble, my lord, page number 8. On the lower paragraph, bottommost paragraph, where it says, whereas the board of directors of the transferor companies and the board of directors of the transferee company have decided to formulate a scheme of arrangement for the following: A, amalgamation of so-and-so into so-and-so, amalgamation of so-and-so into so-and-so, and it lists out 3 amalgamations which take place, my lord. On page number 9, on paragraph 2, it reads, the composite scheme of arrangement is presented under section 391 and 394 of the Erstwhile Companies Act 1956. And therein it lists the total ambit of what the scheme of arrangement is. It comprises of 3 amalgamations or 3 mergers that are taking place. And it comprises of 1 reorganization of equity capital, my lord. That is broadly what this scheme was drafted to achieve, my lord. And by this honorable court sanctioning the scheme in 2011, my lord, the exact date I'll confirm, my lord, but by virtue of this.
What is important is you're saying something about the lease and the sale.
Please, my lord.
Where is that?
That is in my affidavit and schedule of assets, my lord.
No, in the scheme, it is not there.
In the scheme, my lord, certain schemes have a separate schedule that is part of the scheme itself. But in certain schemes, they will not have a schedule when there are multiple properties involved in different jurisdiction, my lord. Therefore, in that particular jurisdiction, this is a scheme that had to be sanctioned by the High Court of Bombay in Maharashtra, the High Court of Ahmedabad in Gujarat, and it's also before this honorable court, my lord. Now, in terms of this honorable court, I have to only produce whatever assets which are within the jurisdiction of the state of Karnataka, because that is the only assets.
In respect of that, I'm asking.
Yes, my lord. That is there in my affidavit and schedule of assets, my lord. If my lords has my affidavit and schedule of assets in page number 6, my lord.
Dated.
This is dated the 10th of August 2012, my lord.
Yes.
My lord, in page number 6, my lord.
Yes.
Page number 6, it reads schedule of assets of transferor company number 2. Now, my lord, the previous page lists out all the assets that are situated in the state of Gujarat. This page lists out all the assets that are situated in the state of Karnataka. So here also a bifurcation is made wherein it says short description of freehold properties, and in the part 2 it says short description of leasehold properties. In terms of freehold properties, I've mentioned plot 6A and 6B and thereafter the address relevant to said freehold property. In terms of leasehold property as well, I have clearly demarcated the same under part 2, my lord. Now my submission is, even though I have made this,
Not able to find where, what you are.
my lord, it's page number 6 of my affidavit and schedule of assets, my lord.
Yes.
On page number 6, my lords has the heading schedule of assets of transferor company number 2. My lord, this is where I have given a bifurcation of the freehold and leasehold property that's situated in the state of Karnataka. And clearly I have mentioned in my affidavit that part 2 relates to leasehold rights, which are being transferred by virtue of the scheme. The contention of the state government is that they will go ahead and value both freehold property and leasehold property under the ambit of Article 24 of the Karnataka Stamp Act. My submission is that Article 24 is very clear and categorical in terms of how it reads. There is no scope for interpretation wherein it is only freehold rights that are being subject to stamp duty. Even for a moment, keeping the Stamp Act aside, by sheer logic itself, my lord, this is a mere leasehold right. If the state government taxes me on this leasehold right, assuming it to be a freehold right, tomorrow at a later date, if this leasehold land does not get allotted to me as freehold land, owing to various conditions being there in the KIDB lease cum sale agreement, then invariably I would have paid a higher stamp duty, even though the said land has not been made as freehold land, which is under my free and unencumbered usage, my lord. That is my cardinal submission.
Precisely why I was asking you about the scheme.
Please,
And
my lord.
what are the rights of your client?
Please, my lord.
That are flowing from the scheme?
Please,
and
ma'am.
how whether it has to be the rights in the property are delivered to you
Please,
or
ma'am.
transferred to you. Is that for that understanding that I'm asking you?
My lord, I have a copy of the lease cum sale agreement which pertains to this
Yes.
particular asset, my lord. I have filed this via a memo of production of documents dated 11/7/24, my lord.
11/7/24.
Please, my lord.
Yeah.
My lord, this is the memo for production of document of the lease cum sale agreement dated 12 September 1995, my lord, which has been entered into between KIADB and the petitioner company, my lord. Now, this illustrates all the leasehold rights which are being granted by KIADB, and there are also certain conditions which need to be satisfied for an eventual sale of said property to take place. My lord, my instructions are that owing to certain litigation that is transpiring, the petitioner company has not been able to convert.
Let's see. Let's just see.
Please, ma'am.
What this document speaks about.
Please, madam.
Please point out that.
My lord, the schedule of the lease cum sale agreement, my lord.
Karnataka Industrial Area Development Board
Please, my lord.
is a lessor.
Yes,
You are
ma'am.
the lessee.
Please, my lord.
Uh,
And the property that is subject matter of this lease cum sale agreement is on page number 12 of my memo, my lord.
Let's see the terms and conditions.
Please, my lord. My lord, para 2 of the lease cum sale agreement. The lessee with the intent to bind all persons whatsoever hands the demise premises may come doth hereby covenant with the lesser as follows. A, during the said term hereby created to pay into the lesser the said rent at the time and days and in the manner herein before appointed by the payment thereof, clear of all deductions, to pay all future taxes, not to make any excavation upon any part of the said land, hereby demised or remove any stand, stone, gravel. My lord, it's a detailed list, my lord, of what may be included in any lease cum sale agreement between KIDB and any petitioner company, my lord. In fact, the KIDB has a necessary template which it follows, and this is only a template of all the rights that are present between the petitioner companies, my lord. Under clause Q also, my lord, on page number 9, it clearly says that the lessee shall not alienate the demised premises or any part thereof or the building that may be constructed thereon during the period of the lease.
So in respect of this lease deed, considering it as a sale,
Please, my lord.
they have determined the stamp duty according to.
Please, my lord. They have, under the assumption that this is a sale of immovable property, even
Yes.
though I do not have all.
Yes,
Report has been furnished, well.
no, on what basis it is furnished that you have to tell the court, it is a lease.
So I'll seek instruction. Kindly put it on next Thursday.
The request of the government, Peter, this is matter on 30th.
Please.
Serial number 37.
Not serial number 37.
Appear for respondent number 2.
Appear for respondent number 3, my lord.
In this case, in the connected matter 340, CA 340, there is an order for valuation of the property, which is also the subject matter of this property, against which we have preferred appeal before the Supreme Court. The matter is pending and the order has been stayed.
Yes.
I'm filing the memo.
My lords, and for respondent number 3, we have filed our wakalat in January first week, my lords. I kindly pray some time to file our objections in this matter.
It is submitted that the.
May I make submission, my lord? This is true in terms of one of the two CAs listed, my lord. 273 is that in question, my lord. The other CA, my lord, I want to make brief submissions, my lord. It is not concerning that.
What do you say? He says that whatever that order you're referring to is in connection with CA 273.
It is, my lord.
And you want to make submission?
On 385, my lord. 385, my lord. Where serial number 5, 6, sub-serial number 5 and 6, my lord.
Sufficiency of service of notice in respect of R2.
Please, my lord, it is served.
Item delivered to addressee.
R2, my lord. Please, my lord. The other small submission, my lord, the
Memo.
CA is, we can finish 273, my lord.
273.
Yes, state, my lord.
Now, CA number 273. Take that. In respect of CA number 273 of 23, a memo is filed stating that the applicant had filed stated that against the order passed by this court, they filed an appeal in OSA number 3 of 2024, which is dismissed against the said order. They have filed an appeal, that is SLP number 27809 of 2024. And an order of stay, judgment and order dated 26/7/2024 in OSA number 3 of 2024 is granted. Considering the same, adjourn this matter, list this matter on 18th of March is next IA.
One more submission in this. See, in this CA, Shanti Bhushan is shown as appearing for R1. Actually, in fact, on the last date of occasion, Madhukara Deshpande was name is to be shown. There is an order.
CA 273, where is his name printed?
Respondent number 1 for respondent number 1. Yes.
Where do you find from the copy?
Right side, my lord. 1, 2, 3, 4, 5, 6th name from the bottom.
DST. Who is appearing?
Madhukar Deshpande.
It is submitted that in place of
There is already an order on the last date to
uh,
reset it.
already on the last occasion, this court has observed that for R1, so and so, take that name, is appearing. Registry is directed to delete the name of so and so and print the name of so and so. Yes, then coming to CA number,
385, my lord.
CA number 385. Let's see that.
My lord, respondent 2 is
R2.
present here, my lord. He seems to be respondent 2, my lord. The application is with respect to, my lord, putting, deferring confirmation of certain leases which were auctioned, my lord. The respondent, at least respondent number 2, my lord, he confirms with the deferring, my lord. He wants his EMD back, which we are okay in giving, my lord. With respect to 4 other respondents, my lord.
For notice to R2 is served and R2 is also present before the court. We'll just look at the cost.
Please,
cost
ma'am.
list, then we
Please.
can, what you
The
want.
last 4 names are served for.
Objections filed by R1 and R5, so and so. Or dealing kept below.
If R3 and R4 wish to file any objections to 3.
Yes, my lords, we have our objections. I seek some time, my lord, since we filed our wakalat in January first week. R3, my lords, respondent number 3.
R3.
We have our objections, my lord.
For the
I praise
R3
for some time.
Wants to file his objections and seeks time. You are referring for?
R4, my lord.
R4, you also want time. R4 also seeks time. This is matter, or for the other matter, date is given, same day.
May I make one submission, my lord? The amount, the matter is with respect to refund of EMD and deferring lease, my lord. With respect to R2, he also wants the same. So, so far as R2 is concerned, if it may be allowed and remaining ones kept pending on the next day, we can at least repay him the money back that he wants.
So it can be independently then dealt
Please,
with.
my lord. They are all different, my lord. This is with respect to rental of properties in UB Tower, my lord, across the road.
No, he doesn't have to come on record, doesn't have to say anything.
Please, my lord, he wants what we are asking for. He
Let
also
him say that,
that.
not orally.
Please, my lord,
How can he say orally?
he has given us a written email with
No,
respect.
let him, because it is before the court, let him formally file. If he is ready to file, I'll take up this matter on next Thursday, 30th. In the meantime, you file, we'll pass orders as far as
Next
your
Thursday.
case is concerned, next Thursday.
Yes.
As
Please,
far as
madam.
the case.
Yes.
For others, on 3rd. Yes.
3rd February. 3rd February.
No, 3rd March in respect of
Please,
CA number 273.
please.
In respect of the CA 385, it is on
Next Thursday.
next Thursday.
Much obliged.
On that day, we'll decide as far as R2 is concerned.
That's all.
Yes, 38.
Number 38.
Please, my lord. Read.
My lord, seal number 38, appearing for the petitioner company. This is also a similar matter which is before this court for the purpose of stamp duty adjudication. I have
Posted the other matter.
on January, my lord, next Thursday, my lord, 30th of January.
Next Thursday, at the request of Learned Government Advocate. Yes, next 39.
Number 39.
The scheme of amalgamation where the scheme has been allowed, it relates to payment of stamp duty. Now, the point that came up for consideration was whether the compensation that is to be received by the transferor company and which would accrue or inure to the benefit of the transferee company would be liable to stamp duty under the Karnataka Stamp Act. That was the point that came up for consideration. And Milords, there was a problem that we faced. After filing the affidavit indicating the stamp duty to be paid, we then realized that 2 properties, major properties, have been acquired prior to the scheme of amalgamation, even prior to the petition being filed. So then we made amends to the affidavit, and then we filed the modified affidavit indicating the stamp duty that we would be liable to pay. But then the question that came up for consideration is whether the compensation that would be received by the transferee would be liable to stamp duty. Milords, I have furnished a couple of case laws on the point, Milords, to indicate that compensation would not be liable to stamp duty under the Karnataka Stamp Act. I have filed it on the last date of hearing, Milords.
So government advocate,
Please, next Thursday, madam.
We have
I don't have
furnished-
file.
give him the
We
judgment.
furnished the case laws. We also filed it into the court on
Thursday.
14/11/2000.
Thursday.
Much obliged.
Number 40.
One copy ಕೊಡಕ್ಕಾಗುತ್ತಾ?
Serial number 40.
Please, my lord, appear for the official
the
liquidator
file,
in 40.1 and 40.2, my lord. We need 2 weeks time, my lord. We have requested the jurisdiction police authorities to find out the correct address.
1 6.
We need 2 weeks time to.
Official liquidator seeks 2 weeks time
File.
to find out the
Correct address of R1, your lord, R2, your lord.
of R2.
Yes, the
Please. R1 is served and placed.
Matter on 6th of March.
one copy.
Yes,
Serial
right.
number 41.
I appear for the petitioner in this matter. This also relates to payment of stamp duty, but my humble submission is here, this is a demerger where actually we are not liable to pay any stamp duty. We have indicated it. In fact, the valuation that was given by the government
Hearing
was
on Thursday.
not in order.
Mr. Gan,
We have also filed an affidavit clarifying the position.
30th. Thursday.
Much obliged.
so that we'll give an opportunity to him.
Much obliged.
Yes.
Serial number 42.
Similar.
Now, the government has to file the evaluation. The scheme of
Yes,
amalgamation was recalled.
Government advocate,
Thursday, my lord. Finally,
Thursday.
please.
This also Thursday, at the request of then government advocate. Yes.
For admission matter, serial number 43.
Copy.
DKV Murthy for petitioner.
My lords, I appear for the petition.
Because there are certain annexures in the petition that we don't have copies of. In fact, we had requested the petitioner council, but
Then
even they
counsel for
don't
the
have.
Petition shall serve all the annexures.
My lords,
the
even
council
they in
is
fact
telling for
don't
the
have it. We'll
POs.
apply and.
Huh?
They in
They
fact
will-
don't have the
they have a-
copies either. So we'll apply and get it. My lords, I request for 2 weeks to obtain it from the office.
My lord, one more submission. Regarding the settlement talks, we have not arrived at any settlement talks. Therefore, the proceedings will be carried forward in the next day.
This matter on 11th of March. At the request
Wait.
of the council for the.
Serial number 44. Vivek Holla for petitioner. Swami MM.
This case, I'm appearing for the proposed defendant, proposed respondent. I need 2 weeks time to file my objection.
Then council appearing for proposed respondent seeks 2 weeks time. This is matter on 12th of March.
Grateful.
Yes.
Serial number 45. Abhinav R.
I appear for the petitioners, my lords, kindly. I request to have it a matter on the next week, my lords. Senior is on his legs in another court.
At the request on Thursday, 30th.
Grateful.
Serial number 46.
46, my lord, I appear for the respondent. I'm praying 2 days time to file my memo of compliance for paying the costs, my
Who
lord.
appears for the petitioner?
Petitioner Deepak.
Appearing for
for
petitioner,
petitioner,
my
my
lord.
lord. The application was filed to transfer this from this court to NCL to my lordship. In the last date, they told they have to file the objections. It was allowed by the cost, my lordship. They have not paid the cost and also the objection is not
Yes.
filed. My lordship.
I'm seeking 2 days time to pay the cost and file the memo of compliance to that effect, my lords. I'll also file
Whenever
my
you-
objections.
When a time is stipulated, you have to do it.
Please, my lords. My
This
apologies.
is matter
I
on
shall,
23/1/2025, subject to payment of costs of rupees 5,000 payable by the respondent to the petition. Now we'll impose another 5,000 within next 2 weeks, 2 days you do that.
my lords, my sincerest apologies. I shall pay the costs by tomorrow and I will file the memo of compliance in 1 or 2
This
days,
is
my
matter
lords.
tomorrow.
Grateful, my lords.
Much obliged, my lord.
Arguments. Serial number 47.
What is 7, my lord?
Yes.
For the respondent 4, my lords.
Respondent 2, on time ಆಗ್ಬೋದು ಸಿನೋಪಿಸಿಸ್ ಮಾಡ್ತೀವಿ 1 week time ಆಗ್ಬೋದು.
Yes, what is this matter? Oil.
We'll take it up next week, my lord, because it requires more. Full argument is required, my lord, half an hour is.
What
All
is
this,
this?
all these matters, my lord.
Yes, my lord.
Yes.
My lord, these are matters related to non-submission of statement of care, they have not given the books.
Books of
record
account.
when The company came in binding up. And my lords, yes, my lord, this is what it relates to, my lord. So now, my lords, the matter went to CPC, the evidence of the.
Everything is
witness
filled.
Was recorded, now they have come finally back for argument. If they want to argue, we have given the synopsis list of dates.
We'll also
Yes.
file a synopsis and list of dates, weeks time maybe.
Request of land council respondents. List this matter on 19th of March.
Serial number 48. Yes, Mahadevan. official
My lord, 48, my lord.
Simply Gopal. Singh.
Respondent, first and second respondent.
Yes.
Same matter, my
Same.
lord, 454, 468, non-submission of books and record, non-submission of SOA. Of course, we have given list of offices and authorities, my lord, it's up for argument.
Yes,
I pay for R1 and R2, my lord.
what you pray?
They have to commence their argument today.
You are not ready?
My lord, I'm ready, my lord. Likely to take more time, my lord. Only thing, my lord.
Thursday,
This I have to read evidence and I have to do. Except that, my lord, I have no problem. No.
Saturday,
I-
this coming Saturday.
My lord, Saturday, my lord, I'm not in station, my lord. Thursday, my lord, next Thursday, 30th, my lord.
Thursday, how many matters? Court can accommodate on one Thursday? Yes.
49.
Please, my lord, I appear for the official liquidator on the matter. Or it's an 543 application, not for recovery against the respondent.
I request 1 week time. Your Lordship.
Chandana Tariga.
Evidence is already completed, your lordship.
Coming for arguments now, final hearing.
Next
This
week,
Saturday, we'll have this Saturday.
next Saturday.
Every Saturday you want, this is not a working day.
Next week, my lordship.
Thursday.
Serial number 50. Achirita Sahi.
50.
My lords, regarding this, I would like to say it's up for final hearing. The panel advocate who was handling this matter is down with fever.
Is
So-
it now?
Down with fever, my lords. So it can be taken on Saturday or Thursday, next Thursday, my lord, she'll be
Next
all right.
Thursday. Yes.
51. Serial number 51.
What happened to 50?
50 only. Now it is called answer.
No, what, 49 is next Thursday.
50, my lord, the panel council is.
This
Similar, my lord,
50 you are
same-
referring to.
Same
Yes,
company, my lord.
yes, I thought it is in 49.
51.
51, my lord, non-filing of the list of authorities. We
IH and
will file it within.
Where is the council correspondent? These are all under all in final hearing.
Yes, ma'am.
This also, what about this? This can be posted on Saturday?
Yes, my lord.
Saturday? Yes,
Saturday.
52.
25 only. Serial number 52.
There.
I appeal for the petition.
For the
Anisha
respondent,
and-
my lord, short accommodation may be granted. February 5th onwards, my lord.
This is matter on 18th of March.
Obligation.
Serial number 53.
My lord, I am appealing for respondent, my lord.
Petitioner, my lord.
So petitioner had advanced a loan, 20 crore to the respondent.
We'll have these two matters next Thursday. 30th.
53 and 54. Serial number, list number 2.
No, 54 you call so that it comes.
List number, serial number 54.
Yes,
So
I'm
your
appearing for
arrest-
the respondent in this matter.
Chandrasekhar
Next
Reddy.
Thursday.
Please, my lord.
Yes.
Let's 2 weeks time may be granted, my lord, because
List number.
the arguing council has undergone
If it
knee
is- if
surgery.
it is 2 weeks, it has to go beyond February. 18th March.
Please, my lord.
Yes.
List number 2. Serial number 2. One urgent.
This case.
Yes.
Going that.
My lords, senior my lords is end up in other court, it can be taken up on Tuesday. Without the copy of the shared parenting plan with the other side. I'll file
They've given
for
it to us today, but they are insisting on those two things, my lord. One is passport and other is shared expenses, my lord. And he is not paying any maintenance at all.
That
There is the question of.
Sir, Arun Bondra said it will be.
I would put forth this with my senior.
We'll
file
have it
this-
tomorrow.
My lords, it can be taken up on Tuesday if possible. It's tomorrow. There's some.
Then fourth, my lord, please. Then fourth, my
Uh,
lord. Third also, third also is fine.
Next week, 29. 29?
I believe they have some other cases, Lord, where they have to file objections and other.
Third, we'll have it on third.
Third.
3rd February.
It's not my problem. Lord.
3 and 4.
Interim orders, my lord, will come.
Interim order earlier granted is extended till then. Yes,
3 and
fine.
4 urgent. Serial number 5. A. Madhusudan Rao, awaiting service of notice in respect of R2. Non-filing of application for substituted service.
Finally, a week's time is granted for filing the application for substituted service. or else the petition shall stand dismissed. And as far as R2 is concerned, without further reference to the court. Next 6.
Serial number 6. Madhvacharyam for petitioner, furnishing of PF and cover.
List this matter tomorrow. 7.
Serial number 7.
Well, 7, my lord.
Deepak Shetty.
So far as respondent number 1, my lord, filed the application, there are some objection. So far as 1, 2, 5 and 3, my lord, that they are not the necessary party because we have.
Have you filed a memo?
Notice
Have to
may
file
be
a memo to
dispatched.
that effect
I will file now.
tomorrow,
Well-
7 tomorrow, is 8,
Serial number 8.
Filing the dispensation memo for R2 and R3.
in 8. Take
R2,
that.
R2 and 3 are the formal parties, my lord, hence I am dispensing.
R1 is served.
R1 served, they are the contesting party, R1.
Yes. A memo is filed stating that R2 and 3 are not the necessary parties to this application. And R1 is only the contesting respondent. Memo is taken on record and the notice to R2 to 3 is dispensed with. List this matter on Wednesday.
Next Wednesday.
Yes.
29.
Interim order can be extended.
Interim order earlier granted is extended till then. Yes, 9.
Serial number 9.
Lords, in this matter, my lords. So far as service of notice to respondent number 8 and 9, my lords, I have filed a memo for dispensation as they are placed ex parte before the trial court.
A memo
And
is
that-
filed. Take out that memo.
Memo
A memo,
21/125. And for
no, let's, first we'll complete this.
21/525.
A memo is filed seeking the dispensation of notice to R8 and respondent number 8 and 9, as they were set ex parte before the trial court. Accordingly, memo is taken on record and notice to R8 and 9 is dispensed with. Next,
Similarly, 11 also, my lords. 11 also is.
file
ex
another
parte-
memo.
No, same, in that memo only I have stated.
In that only you have
Yeah,
stated.
you have stated.
So it is R8, R9,
R8,
R11.
9, 11. I'm seeking dispensation on the ground that they are placed ex parte before the trial court. And 12 to 14, I'm seeking dispensation on the ground that they are my vendors. Therefore, they are not agreed parties.
They are not the necessary parties according
Yes.
to you, as far as this
They are not
application.
agreed, they will not be agreed, they are pro forma
In
respondent.
the same, that is also in the same memo.
Same memo.
In respect of R12, R13 and R14, it is, in the memo, it is stated that they are the vendors and they are not the agreed parties as far as impugned order is concerned. As such, notice to them may be dispensed with. According,
R5 and R6, your lordship had permitted me to take out service on the council appearing before the trial.
accordingly,
court. I have
notice to
served.
them is dispensed with. Next, R5 to R6,
I have served on the council appearing
where is
representative.
that memo?
That is also, I have mentioned in the very same memo and I have filed an acknowledgement for that.
This court had permitted the petitioner to take out notice on the advocate appearing before the trial court for the respondent number 5 and 6. Then counsel has made a memo to the effect that he has served the notice on, where is that?
And Shri B. Keshava Murthy.
That he had served the notice on 1 Shri P. Keshavamurthy, advocate appearing. Registry is directed to print the name of Mr. P. Keshavamurthy.
Lords, there is some urgency.
Tomorrow will take.
Tomorrow auction is scheduled, my lords, in respect of.
Tomorrow will take 10:30. Top of
10:30.
the list, it's already 4:30.
Please, 10 tomorrow.
Because the complete list is, has to go.
Top of-
Tomorrow, on the top of the list.
Grateful.
Yes.
Serial number 10. Hearing on interlocutor applications.
For the petitioners, my lord.
Respondents.
My lord, seniors held up in another court.
Tomorrow.
Yes.
Serial number 11.
No, not tomorrow. Day after. They are day after tomorrow.
Day after.
Serial number 11. Rahul S. Reddy.
Tomorrow.
Serial number 12. A. Madhusudan Rao.
Case is not served, my lordship.
Right now.
Yeah, 125. Filing objection, my lord.
In this case, we have filed a LR application, my lord, to bring the LRs of
Notice is ordered in that.
notice to be added. It will-
IA number, in IA number. Only one IA, everything is filed.
Only one item. Only one item.
Notice on IA number 1 of 25.
Serial number 13.
Well, stay may be extended. Yeah.
Look at it, if the interim stay is extended, extend. Yes, 13.
13. Preliminary hearing
Tomorrow.
13, Chandranath Ariga.
Tomorrow. Yes, 14.
14. Preliminary hearing group.
Tomorrow?
Monday,
Tomorrow?
Monday.
Oh, Monday, not Monday, Tuesday. Tuesday.
28 one. Cell number 15.
Taken
Raghavendra
up on
B.
Tuesday.
Tuesday.
Great.
Cell
16.
number 16.
I appear for the petitioner, my lords. My lords,
Tomorrow?
we would be retiring from the matter, my lord, though I've made several efforts to gather some information, my lords. I've not secured that, my lord, so I'm forced to retire, my lords. I'll file necessary application to that effect.
This matter on 30th, 29th.
Grateful.
Yes,
Cell
17.
number 17. Sandeep Lehare.
Tomorrow.
Cell number 18. Balagangadhar GS.
Tomorrow.
Cell number 19.
Tomorrow.
Cell number 20.
Ready?
Next week. Ready?
Notices are served. Who appears for the respondent?
Respondent B.R. Vishwanath for R2.
Tomorrow?
Next week, anytime.
Next Friday.
Please. Interim order may kindly be extended.
Tomorrow, all granted is extended till then.
Please.
Cell number 21.
My lord, your lordship may have it day after tomorrow, my lord. I will come there to the, in person, my lord,
What is
physically
this
I will.
arguments?
For R
What is this caption?
arguments.
My lord, I represent respondents 2 to 8, my lord.
This is matter, day after tomorrow is Friday, Saturday. Let's have it on Tuesday. Even that.
R3 is dead, my lord. R3 is dead.
Arguments.
We have to file, my lord, appropriate applications. My
Yes.
junior could not
Tell
answer
them
your
to
lord.
write on that.
Yes, my lord.
Yes, Tuesday.
Please, my lord. Highly obliged.
These two serial number 2, the date was fixed for 3rd of February. Can it be on 4th of February?
Yes, my lord. The
4th of
was-
February.
My lords, I make one submission.
That number you take.
This two serial number 2, my lord.
Ah.
Writ petition 1644.
4th of February.
My lord, serial number 5, my lord, in second list. Interim order may be extended, my lord.
My lord,
I've already said if the interim order is set to extend.
Please.
my lord, list to serial
Serial
number
number 5.
10.
Stand, file, stand.
Lord,
My
list to
lord,
serial number 10, let the interim order may be extended, my lord.
Wherever there is interim order in adjourned matters, it will be extended.
Much obliged.
If it is
Serial
not
number
there,
21 also, my lord.
if it is
Senior, serial number 21 also,
Yes,
interim
yes,
order. may
yes.
be extended. Please, my lord. Highly obliged. my lord.
ಯಾವ್ದೋ ಒಂದು ಮಾತ್ರ